We wanted to make a mention, your lordships, on the side of the state.
Give all the memos.
This
Pass
is an
on the-
urgent matter, my lord, sir.
Pass on the memos.
May I get able to disturb my lord, I am busy. Item 39, this is GST matter, I remember last occasion I mentioned. Can you get at 2 p.m, item 49?
In this item, item number 49, I am there for the petition.
Let us see, Mr. Reed.
Let us see, we'll try to reach today, don't worry.
Oblige, man, oblige.
49, I am for the petition. The last occasion, they have solved the counter affidavit, they are filing the rejoinder affidavit.
Let it be called, sir. Inform us when it is called.
Weekly daily list, fresh admission,
Time of call, that's, yes.
fresh admission.
Contractor, degree engineer, contractor. Now, next up, one is the contract license. Then, next up, human is eligible to work up to 20 crores. But the next up, the imposition of condition that is my lord, the running page 17.
I could not understand. To be very frank.
The petitioner is a class contractor, my engineer contractor.
Right.
And annexed to A class contractor and eligible to work up to 20 floors of it. Then my lord, the imposition of conditions is not eligible to work up to even 8 floors.
I could not get this sentence. I could not get this sentence, what you said last.
But
You are a A-class contractor, engineer contractor.
engineer,
As per the office memorandum, you are permitted to work up to 20 crores.
20 crores.
What
But the,
what
but the department impose certain conditions.
What certain conditions?
Condition,
I don't know what that
condition in the tender call notice. The tender call notice.
But what that condition, sir?
Now, that is the 75.
That
That
disencourages
is-
you to participate. Tell us that what.
Running for 17.
17.
17, madam. Clause 7(1), 17(1). That is 75% of estimator cost, madam.
What, 17 what?
17(1). Running for 17.
In the table.
The table.
No, I understand. So what is the 75% of the estimated cost put to the tender during any pre-project year?
The similar nature of work. The similar nature of work, that is bridge or road or any type of work minor. The condition imposed 75% estimated cost should be completed in the previous 3 years.
Yes, true.
Then because I am an engineer contractor minor,
Correct.
I have a technical know-how.
Correct.
But the certain condition minor, I could not able to do.
If they say that if you are a contractor, if you have done certain works during the last 3 years, that would really make you eligible to work.
Minor.
So they have not said the 10%, they have said the
75%, not 75.
You must have done.
But it is the condition of one department. But the annexed 4 minor, the state government in the same department, another department minor, such condition was not imposed.
Nature of work same.
No, this is a road work, this is a bridge work. But in the road work minor, certain small bridge is there minor.
Road,
Road work and bridge work.
sir.
In the road work minor,
There is a
certain
bridge
bridge.
already constructed. And the bridge is made of motorable one.
Minor.
So in order to just repair or do this motorable, the road, this is really that is done. It has got it's a different nature of work.
My lord, regarding construction of bridge and regarding construction
The
of.
bridge is that there is an expertise
My-
which is required.
I am an engineer.
Bridge means that the angles have to be taken care of. There is an expertise in this regard, but the moment the bridge is there, which road is to be constructed like a road
My lord, regarding
on the
construction,
bridge.
I am an engineer contractor. Because why I filed this case, man? Because I am an engineer contractor. I have no technical know-how. Man.
Of
The general.
technical know-how does not mean that everybody who has a technical know-how will, if they have put a condition, the conditions must be reasonable. The conditions must be onerous. It should not be onerous in that sense, which would really disentitle you.
But because I am an engineer contractor, condition should not be imposed to me.
There is there any distinction between engineer contractor and non-engineer contractor?
Yes, my regarding payment of certain dues minor. That is a condition minor, relaxation minor.
No, I'm more concerned with the nature of the work to be done. Whether the payment is to be released or not to be released is a separate issue. Now we are concerned with the construction. So whether you fulfill all the conditions which are there for a technical bed. Your experience is also very important.
Well, in that, even this will be continue. Minor. I shall never achieve this condition in my lifetime.
What?
75% because none of the work I am eligible.
None of them, and I do not know.
But regarding
Previous this time or previous, they have quoted what? Have they quoted this conditions in the previous tender?
that's my in all
So
all tenders.
all the tenders that
Then and I
within
never
the domain.
I said never eligible man. Because what as per the government notification matter, I am eligible to 20 crores man. This is the 8 crores one. Only 8 crores work, my lord. Am I engineer contractor?
Sir, any law that we can struck down, you wanted to struck down this particular conditions. Please show us the law that it fails on the test of reasonability. Show us the law that they have no authority to impose. Show us the law that by imposing, there is a nepotism, there is a bias. They wanted to exclude a particular class of a person which comes within the homogeneous class. Show us the law, no difficulty. You are making when you are filing a pleading, you should be sanguine about your stats, sir.
That's true, my lord.
And you know that there are very limited scope for interference. Is the wisdom of the authority floating a tender that what conditions have to be put in?
Next week, next week.
That's a difficulty with me. Whenever I put some certain questions, always encourages adjournment. these are the basic broad fundamental principles when can a court interfere at the tender stage. More particularly when the conditions are imposed. These are the basic fundamental principles. We should come ready with that.
Next is madam.
We need no result.
Next is the crime and risk madam.
Very difficult.
Next is.
You have to show that they were never insisted for these kind of conditions. It is for the first time they have insisted this kind of conditions with the malice, with some motive. You show us, demonstrate. Very not in a very clumsy manner you have drafted. Not a single case is made out for interference. Can we go beyond the pleading, sir? Tell us. We have to decide on the basis of the pleading, sir, what you have stated. But these points we can not. Tell us what to do, sir. Advise us.
Next week, I think. Next week, regarding police.
That's the advice.
July last. 28/7/2025. Item number 3.
I don't know, feel that the seniors are out of section today. Very important.
Your work comments prior to coming in force of the GST.
Sir, matter regarding the read petition has been filed against the order passed by the Patna 1. Pursuant to the order passed by
Annexure? Challenging what annexure, sir?
challenging the order passed by opposite party number 1.
When, where it is annexed? 7/7/2023.
7/3/2020.
7?
Regarding the termination of contract and the order which has been challenged here.
Where is the order? 7/3/2020.
7/7/2023.
That is what I asked you. Annexure
Yes,
E.
I will pass.
As for the revised guidelines, which were challenged before this court and the guidelines was upheld. In Harish case. This computation under annexure A, which is approached to the order. Asking you to. Because it asked, they want to recover this amount from you, rather you are referred to pay the government.
Firstly, the conducting council.
So
Yes, senior.
this computation are you challenging?
The seniors knows better. Senior knows better, Your Lordship. Actually, he is the conducting council here, so I'm paying for an argument.
So you started arguing as if you thought that everything will go in your favor.
I told from the
Then one who start must finish.
No, Your Lordship,
You have started, you finish.
I told from the very beginning that my senior is out of session and I'm paying for an argument.
I believe that's my incompetence. I did not hear that.
Pardon, Your Lordship, but
Taking a chance is a very risky thing.
28th of July. Okay. Okay. 28th of July. Item number 4.
The challenge to Alex to fight. And I've been told in the last hearing. And talking the question that there was Tahsildar or the mining officer has the jurisdiction.
Yes, after the amendment having withdrawn.
Mine.
This is by Tahsildar.
May I just.
Tahsildar has the power, your lordship. We have also executed,
Right.
we have also executed instructions, your lordship, explaining how the SOP say, how the Tahsildar is going to see.
May.
But your lordship, I may be given 2 weeks time to file a comprehensive counter explaining everything.
Question of counter, sir. It's a delegation of a power and government of power by virtue of an extent of the statutory provisions. So as the GA or a GO, I do not know what. Terminology you use
Your
here.
lordship,
Either it is a government order or a government. That's true.
yes, your lordship, rule 50, your lordship.
That permits.
Rule 50 says,
Yes.
revenue assessing authority. The assessment and demand of rents, royalty, fee, or any such due payable
Rule
50 of OMMC concession rules 2016.
Rule 50.
50 your lordship.
Rule 50 is the assessment and the demand of rents, royalty, fees or other payable.
Due payable under this rule shall be made by the deputy director
Or mining officer.
or tahsildar or division forest.
It's not there, sir. That is omitted by the amendment of
Yes, your lordship.
2012.
That was there. So they have given an executive instruction, your lordship.
This has been omitted.
Yes. For that reason, your lordship, this assessment is for a period prior to the coming into force of the notification. And they have given an your lordship, I want to place it,
Man.
They can do it contrary to the provision of this statute. Let us see.
My case is that they cannot do either the mining officer, or the Tahsildar. That's what I'm saying. On the rule, both of them cannot do. That is what I'm saying. Neither the Tahsildar nor the mining officer.
What you sense the pulse of a bench.
Well,
That do not sense the pulse of a bench.
I understand.
Bench is also talking the way you are arguing. We are trying to ascertain that how and in what manner that power is retained with the Tahsildar. Let us see.
point number 7, your lordship.
Sir, you must have decisions in the Well, on the date of exercise of jurisdiction, the law prevailing on that date, that will, the authority.
My guess is that they cannot do it. If your lordship read rule 51 is the source they have exercised in issuing that annexer 5. I'm just reading that rule 51 for a while. Listen.
The first demand was made in 19/11/2022, your lordship, before the coming into force of this amendment act.
I do not know how this is dealt with and how it can be done. You have said that
This is in the
area
transitional.
which is beyond the demise. Or a-
Yes,
as you said, what that's a demarcated.
Yes, your lordship.
area. Then in that event, they have done an excess mining or excavation or whatever.
yes, your lordship. That is
For
what I
that
want.
excess mining, you say the Tahsildar is the competent authority to take a decision. And the entire decision relating to mining is vested upon the mining officer. When you make a artificial segregation, or now it has come into the reality that one power is conferred upon a different authority and one to a different authority, is I would say, is a farcical approach. If somebody has committed a wrong or violated the terms and conditions of the lease relating to mining, then the authority who have granted a lease or the lessor or the authority who is owning the statute, we should take action. It's a breach of the conditions of the lease.
If you like,
That's
that is how the Honorable Apex Court has analyzed it.
Words, Tahsildar, from entire statute of this mining act and rules. Then how
Your
can
lordship, your lordship, there are many facets.
Tahsildar as one of the members of the team.
Your lordship, there are many facets, your lordship, to that after that amendment has come for the transition, your lordship. Because the Tahsildar is still the person who has to demarcate the mining area, your lordship. Secondly, your lordship, after Tahsildar hands over litigation free a project or a mining or a quarry, whatever, minor minerals, your lordship, lease, after the Tahsildar hands over a litigation free certificate, then only the mining officer is going to accept it. Now, this demand was initially made before this rules came into force, your lordship.
Let me consider. When you are allotting a mine,
Yes, your lordship.
you are executing a deed of lease with them. While granting permissions, there must be some document either in the form of a lease or in the form of any other document which permits them to continue with the mining operation. You must have been given a boundary. Now, is the Tahsildar with the help of or a land department, you can go and make a reliance survey of the property. That this is your area where you can continue with the operation of mining. If they transgress that particular boundary, then it is a violation of the permission or approval or document containing the terms and conditions of the operation. And in that event, you are the rule says about the penalty. Correct? The penalty that you talks about that it will be permissible, it's not only liability, but also the penalty which can be imposed sub-rule 2, Roman 2 of clause 2 of rule 1 of rule 51.
Yes, your lordship.
The director or the additional director.
Let me file a compulsive counter, your lordship.
So these
Taking
are
into
pure
all the.
question of law. It's a pure question of law.
Yes, your lordship, let me bring into your lordship's domain all the executive instructions, all the SOPs.
Can it override the statutory provisions?
Under what circumstances, why it has been placed, your lordship, let me put it up
They
for your
depart
lordship.
from the statutory provisions. Even if circumstances so warrant, if there is no power which is given. Rule 15, Tahsildar was there, it was omitted. We did notification dated 27/12/2022.
22. Yes.
It says the assessment and a demand of a rents, royalties, fees, or any other rule payable under these rules. It is not that under the approval or a grant or lease shall be made by the deputy director or a mining officer. Then the Tahsildar was there, which is omitted,
Your lordship.
or a divisional forest officer having jurisdiction.
Yes, your lordship. I wanted to show your lordship in Rule 50 the word Tahsildar that has been omitted. But at that point of time, when this demand was raised, your lordship, this penalty was imposed. At that point of time, these amended rules were not there. So this revenue is there in the revenue department book, your lordship. So the Tahsildars have to collect it, make it litigation free, and hand over the source to the mining officer. That is what.
We have to then think about either section 6 of the general clauses act, and if there is any problem.
Let me
Can you
file.
continue? I'm just asking you, is there any repeal or saving clause in that law? Or you of your own assume the repeal and saving clause?
Let me file a reply, your lordship.
What reply? It's
Let me
a
file a
reply is needed on a factual matters. It is a pure question of law. The law has been amended where the authority is conferred upon a different person. Now it appears the authority which had the jurisdiction prior to the amendment is still exercising such powers. Now the question is under what authority is exercising is a pure question of law. Can it be
Since
given
the
a
rule-
retrospective effect or it will operate prospectively?
The rule is
Whether
also
there is a ceiling
silent.
clause,
The rule
whether
is silent on
it's a
the
pure question of law.
The rule is silent on the revenue that was to be generated prior to the amendment of the Act, Your Lordship.
How
And
the
since
rule
it
to
is
be-
silent, so they have given this executive instruction, Your Lordship.
I am
To
asking
clear
how
it.
the rules are to be framed. It has to be notified. It has to be placed if the central government makes a rule. It has to be placed in the assembly in the house.
Laying down,
Of an assembly.
laying down, 28.
Then it is, bill is passed, then it is transformed into a act. And then after notification in the official gazette, on a date specifying coming in force, it will come into force. Can an executive instruction or administrative instruction can override the legislative power? I'm asking,
Where the rules are silent, Your Lordship.
can it be?
Not
Why
override,
executive
but where the
instruction?
rules are silent, it can, Your Lordship.
It can,
Where the rules are silent,
what?
in issues where the rules are silent, their executive instructions will.
Is not silent. You have conferred a jurisdiction, taken away the jurisdiction from one authority, conferred it or vested upon the another. The only question would be whether it has a retrospective effect, the amendment, or a prospective. If it is prospective, whether the authority power prior to the amendment is retained by virtue of a saving provisions.
There's no saving.
If it is because all the amendments are intended normally.
Let me file a conclusive counter, Your Lordship. For all times to come, the issue can be settled before Your Lordship. So there will be numerous cases coming this way, Your Lordship. So let me file a counter. Let the department say its views.
I do not know why it's so much interested in.
If the department can express its views, Your Lordship, it should come from the department and then only I
I
can.
don't want the views, these are the bigger views.
There are other communications, Your Lordship, that is made between the revenue and disaster management and the steel and mines, Your Lordship, in the transition period, Your Lordship. For the smooth transition from the revenue and disaster management to the steel and mines, there are many letters and communications, Your Lordship, that has been made for the smooth transition, Your Lordship. For that period, Your Lordship, I wanted to place it before Your Lordship. All those communications, Your Lordship.
Rule 51 doesn't confer any adjudicatory authority upon the Tahsildar, Your Lordship, and that's so even if it is Tahsildar or mining officer, it makes no difference. They have adjudicated it. If Your Lordship see the annexure 5, they have imposed a penalty of rupees 5 lakh, which is after the I have been held guilty by a court, competent court. So they can only prosecute me. Lordship may kindly have that penalty part, that rule 51. So they have never had the adjudicating power. Now this they have imposed a penalty of rupees 1 crore. May I just place my rule 51. And this rule, OMMC rule, is made under section 15 of the OMMDR Act. And the section 15 doesn't delegate any such power. In fact, section 21 holds the field, MMDR Act.
It's not a court, sir, because we have to spirit. I am also very surprised that the authorities conferred a power, not the court. Even if it's a criminal liability, that's a different one. Because it talks about the compounding of an offense also.
Yes, my lord. I have not
Compounding can only be done
on my consent.
by the court. But here it found that the compounding is done by the authority. And the clause 5 says that if it is compounded, no proceeding would be initiated against it.
That's correct, man. So that
That means the authority is given, the executive authority is given a power to compound it.
that they cannot do, my lord, the lordship can have section 15 of the, because this rule is OMMC rule, this is framed under section 15 of the MMDR Act. The lordship can have that MMDR Act. I'm just drawing your lordship's attention to section 15. No such power has been delegated in favor of the state government to make rule in respect of this. It's only section 22, 23, there is a
Madam, come to 51(2).
that's a seizure power.
If that is the jurisdiction, you are nothing of can do. Two authorities, one imposing the penalty, another. If the Tahsildar cannot initiate a proceeding for removal, if they have transgressed, your case is that beyond the lease,
Beyond the mind.
correct, area. So in that event, two will apply.
And 1, 2, 3, or 4, it's required an adjudication, my lord. They can.
That is what is required. How Tahsildar can confer a power?
Tahsildar is to demarcate the mining area. The Tahsildar,
What power the Tahsildar now invoke? It is rule 51, right? When has he exercised the of section rule 51?
After amendment,
19/11/2022.
after amendment,
This
No,
one,
before amendment.
this one.
Before amendment.
Sure.
That, Your Lordship, I have.
Please show he has exercised power under rule 51 prior to this amendment.
Your Lordship, I see the show-cause notice. I have that letter, Your Lordship. That is what I wanted to place it in before, in a reply, Your Lordship. I have it today.
Is it under rule 51?
Yes, Your Lordship.
show-cause notice is 2/7/2024.
No, Your
Section
Lordship.
3
That's
No, Your
reply.
Lordship. There is,
copy
Your
of the
Lordship,
show-cause I find for
annexure,
filing. This is a filing of
yes, Your Lordship.
shown by the.
Annexure 2 of WPC
HSC is doing a copy
16182.
of the show-cause.
No, my lord, it's a reply.
It's a
16182.
reply to a show-cause.
16182. Page 11, annexure 2. Yes, Your Lordship, it's under 51. 19/11/2022. That letter I have with me, Your Lordship. It's in my WhatsApp, Your Lordship, but I will, that is what I was saying, that I will place all these records before Your Lordship.
No, when this is not a.
This is the notice, Your Lordship. It was initiated in
No, it is not a show-cause.
It is a show.
Please read the text of the letter, sir.
This is
Annexure 2,
yes, Your
1/12/2022.
Your Lordship, the first notice was given in 19/11/2022. Again, it was
1911 notice.
Reference, Your Lordship may see reference.
Yes.
Subject and reference. This office letter, number 6979, dated 19/11/2022. And then again, he
I do not find this. From where you are reading?
page 11, Your Lordship,
Page 12.
WPC 16182.
That is a 2020 letter.
No, Your Lordship, in this Ashish Yadav case.
Why you are in, we are in first one.
First one, Your Lordship, the same.
Yeah,
thing, Your
that's-
Lordship.
yeah,
Same,
okay.
yes.
No, first one.
The notice is not there.
Next.
That is not there, Your Lordship. But here, this is the first letter that was given in 19/11/2022. Again, since they didn't deposit the money, again they were reminded on 2/5/2024. Then this letter follows. This is a third communication.
This is, what is the page number you said?
In Ashish, page 11, Your Lordship. Annexure 2.
Page 11 is 2025.
Yes, Your Lordship, where reference. Reference, Your Lordship. The letter,
12, I do not know, 1/12/2022. The letter is communicating the approval. Where is the show cause? The initiation has to be done. Where is the show cause notice?
I have it here with me in the WhatsApp. Your
Sir,
Lordship.
why you have not annexed the show cause notice? Show us what is the date of the show cause notice.
In fact, I have never received any so called.
So then how you have given a filing of the
In
objection?
2020,
What you have given?
the 24 I have filed, I have received and I have given notice. In 24, I have received the so called.
Where is the show cause notice, sir, which you received?
24, no?
Where have you stated?
No, that is stated my. The reference filing of objection in respect of PR number 2506 dated 2/5/2023.
Which one, first one?
First one. Yes, my lord, at page 13.
This 30.
Yes. And here is also the same, PR number 2506 dated 2/5/2024.
Sir, you said that you have received this intimation subsequent.
This intimation I have received and I have replied.
Where stated that?
I don't know because for me it's in 2024 and I come. I didn't know
Where is
that.
that? You must have stated in your pleading that I have received this show cause notice, this dated so and so, on so and so. Thereafter I replied.
Yes, my lord, paragraph 7. The petitioner humbly submits that after receiving the letter of show cause under next of 3,
Where? You have said, where is that show cause?
that show cause is not.
So
So that's a wrong.
after receiving a show cause,
Hmm.
where is that?
That I was actually asking my friend, it is not.
The first show cause was received by him. I have it here, Your Lordship. On behalf of Mr. Sashank Yadav, Srinivas Senapati, his manager.
File a counter. That's a very defective pleading, sir. And you are saying the everything annexure 3. Such a casual drafting, sir. And you know that it's an interesting point is raised, whether you are raising that whether the Tahsildar can take an action. You are raising that point. And you will not say whether the initiation was prior to the amendment or after the amendment. You will not plead.
Lord, seeking positive is to be that.
Then give your response.
Definitely, you have not settled this.
Your Lordship,
Draft.
3 weeks time.
Definitely, I'm sure.
What will be the reason? But that has to be done.
My lord, I get it. Fine, that's fine.
Fine.
And I take up.
You may try to give you a relief what can. Anyhow,
Let's not stay the proceeding for ease.
what you are not satisfied.
Well, I'm satisfying you, Lord. Allow
We are not satisfied from the pleading. The pleading is defective.
Well, just leaving aside the pleading, let me allow me to place the law. If Lordship can have that 51.
Tell us that if the action is taken prior to coming in force of an amendment act, whether that action would be invalidated automatically after the amendment has come to force. Show the law.
Well, my case is that
Show the law.
the
Show the law.
rule 51.
Rule 51 talks about what can be
Well,
done.
may I just
I'm
place it the
talking
way?
about initiation of the proceeding. If the amendment has been brought,
I'm not saying that.
is it a prospective effect or a retrospective effect?
I'm not arguing on that. My lord, rule 51.
This is the important one.
I'm just leaving that question aside. Let us have rule 51.
Yes. What?
Can have it.
What?
Whenever a person is found extracting or transporting any minor mineral or on whose behalf such extraction or transportation is being made,
Yes.
otherwise than in accordance with this rule, shall be presumed to be a party to illegal extractions or removal of such minor mineral, and every such person shall be punishable with a simple imprisonment for a term which may extend to 2 years or with fine or which may extend to rupees 5 lakhs or both in case of continuing contraventions and with additional fine and so and so. Now, your lordship, I am drawing attention to Annexure 5.
What?
Annexure 5.
They impose 5 lakhs.
Yes, madam.
Let us see. Proceed.
So my case is that is not been adjudicated. How it is to be adjudicated?
Adjudication. Then they impose 5 lakhs.
Yes. I have, so how it is to be adjudicated, your lordship kindly have that.
Yes.
3. No court shall take cognizance of any offence punishable under this rule except the complaint in writing made by such persons or authority mentioned in the clause.
Correct.
So no complaint has been filed.
You do not know, these are the factual disputes.
No, madam, they have never filed. If they
They
say,
have not filed a counter, then it's a factual dispute.
no,
Whether they have initiated on the basis of a complaint, whether they found something at the time of an inspection, they have to disclose.
no, this is a criminal offence, it has to be filed.
Again, I'm saying, that is why I say very interesting. Then subsection 2 of section 51.
Yes, madam. Subsection 2, yes, the director, subsection 2 is, yes, whenever any person trespasses into any land in contravention of the provisions of this law, such trespasser may be served with an order of eviction by so and so officer. Just I'm skipping over because the assistant conservation with their respective
Roman 5 of sub rule 1.
My lord.
Don't look at Roman 5. Roman 4 and 5.
Yes, ma'am.
Please read together. If
Where?
it is purely a criminal offense,
Yes, ma'am.
liable by a criminal court,
Yes.
please tell me whether 4 and 5 can go. Read.
My lord,
Roman 4 and 5.
where the offender agree in writing
Correct.
to compound the offence punishable under these rules.
Correct.
So to
Before whom?
before the director, all the
Can it
officers.
be
Officers.
compounding of a criminal offense can only be granted or done by a the case is initiated. You know that dedicated under the CRPC, there is a dedicated provision that which are the offenses which are compoundable in nature. If the court is the only authority to compound the offense, then why this section was introduced where the authority, the executive authority is given a power to compound? 4, read 5 also.
My lord, in my agreement, with only when I did not
Can
oppose.
it be done? I am
No,
asking.
that cannot-
Suppose the criminal offense is the way which is compoundable in
That
nature.
cannot-
Can a police authority compound it?
That cannot be
I am
done.
asking you.
That cannot be done. And
So then it's a similar way
yes,
how the authority can compound the offense.
so they have not compounded here. This rule is violation of.
When you are taking a plea, that's a criminal offense. It is only the criminal court who can do it.
Yes,
Impose a fine of 5 lakhs.
yes, ma'am.
Is the only criminal court can compound, the impose.
Yes.
Then where is the question of compounding by an executive
And
officer?
that's exactly I'm saying that this is also not incompatible with the act. Your lordship will have that MMD
And
act.
you'll have to challenge this particular provision.
But-
Why is, have you challenged the virus of this provision which is contravention to the
I will show just one second. On MMD act. MMD act.
Difficult, I'm telling you.
MMD act. I have two more provisions I'll show and I'll not show anything. My lordship, can you
I
have?
am asking you, sir. I am asking you are taking a point one after another. You are unable to satisfy us on a first point. You just wanted to bypass
And madam,
from
that's
there.
because the pleading is we can.
I am again asking you, sir, on the proposition of law, you have not challenged the virus. If you do not challenge the virus of a particular provision, it's a subordinate legislation.
Yes, madam.
According to you, the subordinate legislation cannot offend any of the provisions of the substantive act.
Yes, madam.
You are taking this plea.
Yes, madam.
You have not challenged the virus. Have you?
I'm showing another authority notified by the government under the act to do these things. That's what I'm also saying, madam. The another rule 22, section 22, your lordship can have of the MMDR Act. That
What?
no court shall take cognizance of any offence punishable under this act or any rule made thereunder except upon the complaint in writing by persons authorized in this behalf by the central government or the state government. Now, my lord, they have notified in 2009 who are the persons competent to take action. And that is under section
Have you annexed those copies? Have you taken that plea in your pleading? You are arguing at the bar without support of a pleading.
That is.
What is the law the Supreme Court has deprecated that the court will not look into anything which is beyond
My lord, I
the the pleading.
am permitted to just
Why?
amend it.
Unless you amend it, whether we will allow the amendment or will not allow the amendment, that's up to you. Sorry, we cannot look into the document. It does not form part of the record.
This is the statement document.
Whatever, we'll have to plead it. And he may say that it has been subsequently superseded by another. They may. You don't know.
This
Very risky, sir. Very
this
risky.
also affirm
When you make out a case for the first time at the bar, it's very risky, sir.
this
You are making out a case at the bar.
in 2025, it is also by judgment of this honorable court, it is appealed also.
Making out a case at the bar. Because these English and that's why it's all counter cards, sir.
That's why I said, TPS not settled the
I'm told that more versatile in the civil law. Let us talk about the order 6, let us talk about the order 7 and order 8.
In 226,
What is the importance of reading if you do not, you know the civil law,
I know.
that any observations made by the court, he holds the pleading, or any evidence which is not there in support of the pleading, the court will not accept that evidence.
The question.
Now I am asking you, you are relying on this evidence. If it is not in
This
the
is law, my
in the
lord.
Pleading, can the court take the document?
This is
into
rule, my lord.
evidence?
I am not relying upon any evidence. This is rule.
No,
No.
you are relying on a particular notification
Not notification.
or a delegation of a power.
They have ruled. Framed.
This is the part under the Evidence Act. Evidence Act.
It is.
This is to be regarded as a primary evidence.
Yes, madam. But
Primary evidence must be supported by a pleading.
no, my lord,
Now I am
this rule. I
talking civil.
contend.
When I heard
I
that you are a you.
I contend it's a rule.
Then I am talking in a civil perspective.
All right, my lord.
Let us see.
I'm amending it. I'm amending. My anxiety is that they should take any course to measure of recovery. That's what I'm
Unless there is a complete pleading, and you know.
last week I allowed
for Shiv Kumar Chatta's case of the Supreme Court 1993 volume 3 Supreme Court deprecated that the court should not pass an interim order without recording any reasons. I have to record reasons. You know, order 39 rule 2A, and 3B, where the court used to pass an ex parte order must record the reasons.
I'll amend the.
Then I am talking in the civil perspective. I'm
Yes.
just reminding you.
I'll amend it. I'll bring it.
I have to.
Well,
When you know the civil law, then you know that what is the difficult.
I'll add it.
I survived today, your lordship.
Same.
Make out a good key.
Right.
Make out a key that it is there. Look up previous. And kindly consider whether this amendment is to be given a retrospective or a prospective. The word amendment that really stuck. Because in a civil law, if any pleading is amended, it will relate back to the date of the institution of the suit. That is a very fundamental principle.
Yes, ma'am.
So here also, when an amendment is brought into the statute, when it relate back to the date, as if it was there from the beginning, or it is to be, or doctrine or relation back is restricted.
The Garika Patita, it says that if it is a procedural, it helps back to the date of last resort.
Always, I'm giving you when the
My lord.
2002, the CPC was amended.
Yes, ma'am.
In 1999 and 2002, when the problem arises whether it will have a retrospective effect. Shiv Shakti Cooperative.
Yes, ma'am. 115 has been held to-
Says retrospective.
115 has been held to be retrospective.
That's a Shiv Shakti
Yes,
Cooperative.
Shiv Shakti
I'm giving
Cooperative.
you a Supreme Court.
Justice Prasad.
Has to go.
Yes, ma'am.
So you have to be ready with that.
My lord,
Madam, come ready. Because it is amended. There are three ways of bringing a provision. One is by way of an amendment act, by way of a substitution also it can be, and by way of an addition also it can. And when it is coupled with the omission, then one has to understand that what is the implication. What? What is it?
Memo.
These are severe. Yes. Birth case. Birth case.
Seventh of July. Item number 5.
Shortfall of MDQ, that's it, sir. That's it, sir.
Of the three,
No, two. Another.
Hmm?
Date, from chase, I think.
Item number 6.
And in this matter, I conference sought adjournment. I will counter affidavit to that.
You have to, just quickly.
One chapter.
Three weeks. 14th of July. Item 7.
My lord, last day, the honorable court has directed to the government to take instruction in the 30 May 2025.
2 more weeks time you'll have to, he's already written his own, yet to receive it.
No, the significant matter,
No,
why it has come to us,
relating to Gram Panchayati Raj Bank.
and why single bench has taken a partial order on Natric of me. We find the order of the single bench. In the vacation,
My lord,
so it has to be moved before the single. Oh. Judge has observed that the public interest litigation.
Needs some logic.
my lord, the government planning department of Odisha has section 6 lakhs to the repair and reconstruction of the temple. The temple,
Repair and reconstruction or?
the renovation of the temple. But the temple is situated over the coastal area. This is my allegation. Now, in this regard,
It
honorable court,
becomes a PIL.
my lord,
Any of, yes.
then the honorable court has issued notice. My lord,
Capacity not come.
my lord,
Only.
They will go to court, right, stop of them. Nothing from the court of that. So. cannot sanction.
No, no. Annexure 1 is there.
Yes,
File C, minor.
that's the sanction.
Minor, Annexure 1.
Is a sanction.
Minor. Sanction of the Department of Planning.
Correct.
Page 9.
Correct.
Specific terms and conditions. Number 2. The concerned collector commission should ensure that funds are not released oblique utilized for repair, construction by way of renovation, restoration, or repair of a religious institution constructed unauthorized on public land. This is the term and condition given by the department. Therefore, Annexure 3, the people are
No, this is the general direction.
minor,
It is a general direction.
minor, by the department,
The general direction. And it should not be utilized anything on a,
government place, like government land.
then,
But these temple was situated over Gujarat land. Minor, Annexure 2, Annexure 2, Khatiyan, Marwa, page 14, 488, Gujarat,
page,
page 14, 14. Well, 488 plot number, Gujarat.
yes.
Therefore, my prayer is not stop the sanction amount because it's situated in Gujarat land.
Page 11 is a part of the annexure.
Minor,
Page 11.
the part of the annexure. Serial 10 is sanction amount of repair and renovation of Sri Jagannath Temple, Batsarapatam. Serial 10, 6 lakhs.
Yes. Yes.
That's the recovery.
What you were reading, which page you were reading,
Minor,
which page you were just reading?
page 9.
Yes. Can.
Government of Odisha Planning and Convergence Department.
Correct.
Minor, specific terms and conditions.
Where is that?
Middle portion, specific terms and conditions.
What?
Minor,
Terms and conditions, which one?
put on the two clause 1. Roman 1.
Yes.
The concerned collector commission should ensure that the funds are not really oblique utilized for repair, oblique construction by way of renovation, restoration, or repair of religious institution constructed unauthorizedly on public places.
in the area of also, particularly for it the government, it is in the government record.
Chief, this is a record, date is 24/3/1962. Lordship, I have to check the records.
Aspects, please enlighten us on. First aspect is that the plot number which he is referring, whether the temple was actually constructed on that plot number. First, if it is not constructed on that plot, there is no difficulty. You have to see. Secondly, if it has been constructed, must have been constructed much prior. So was there any alteration in the record of rights?
Yes, Your Lordship.
Frequently, Tuomoto or something. So if it is already altered, what is the?
Because it's existing for the around 20 years, that is what his representation says. Your Lordship. The past 20 years, the temple is full.
Sir, the land is
I have to seek instruction on which was.
Now it is also butcher.
Enlighten us.
I will get instructions 2 weeks. 2 weeks time. it is.
10th of July. Item number 8, 14th of July. Item number 8.
Because the was placed on a single judge as a matter relating to Gram Panchayat in issue, but similar other requests are also disposed of by the honorable single judge before vacation. So the honorable court recommended if it is a lecture of PA, so accordingly it is being placed with the observation. Order that 30th May 2020. Although requisition disposed of, but yes, and the issue is in violation of section 47 of the Gram Panchayat Act regarding execution of the work. So prior approval of the Gram Sabha is required. So in this case, without the project being placed in the Gram Sabha, directly BDO send the proposal to the government, to the project director, and it is being approved by the government. So they are not may not be required. But the entire thing,
Ultimately, if the Gran Sabha
yes,
ratifies it,
Yeah.
but the final approval of the government is required.
yes, ma'am. But in
If the government is directly approached, maybe there is a procedural lapses. Does it really renders the entire thing?
No, my lord, we are not recalling the project. So the list it is to be revised because some required projects are left out. So 47 said the work will executed through the Gram Panchayat. But here, the after approval of government, the concerned BDO through the junior engineer the workload is issued in favor of the junior engineer. So they are undertaking the work. So no Panchayat members are involved. No, who are you? We are the sarpanch, man.
And Sarpanch.
So neither the metal place to the Gram Sabha, nor so they may section 47.
That's the hindsight of it. Sarpanch wanted every control over it, both the works as well as the finance.
Sarpanch filed against Silvapur.
Can you maintain a PIL?
But that is why it was originally it was not in the nature of PIS. So under the
You
Gram
are
Panchayat.
an integral part of a democratic polity. You are not nominated but a chosen in a democratic manner. So you are more concerned with the well-being of the peoples of the village. In which you have been selected or you have been elected as a sarpanch. If the project is for the benefit of a larger public, why is a sarpanch citing those technical
Well, I'm not
issues? It is for the benefit of the public.
No, man, I am not. I am not recalling the approved list.
So I understand because what is the hidden agenda is known. Hidden agenda is known. Why Sarpanch wanted everything to be under his control? Means the control of the Panchayat. I'm talking, you are the head of the Panchayat. So naturally, under the complete clutches of the Panchayat.
The junior engineers shall not be the executant of the work.
Let them, it's for the public. What is the nature of the work?
Well,
What is the nature of the work?
the page 24, only maintenance of primary school. So primary school building is there, my lord. So
The bench had passed, or she had argued the
only
case.
same
You're searching the number, you know.
one process.
Rosalind Pradhan. Just taking out.
We have said the Pradhan cannot. We have made.
Yes.
Pradhan cannot.
See, 1889.
Yes, 24.
Person.
Madam, may I pray?
Adjournment.
So, because our complaint is being attended by the collector.
Sir, your competence is decided by both of us. That what is the role of a sarpanch and how it has to be.
But they might be ignoring section 47.
I don't know.
Power to execute work.
This is the matter between Rosalind Pradhan versus State of Odisha, that is WPC number 18389 of 2024 and decided on 29th of April 2025. Sir.
I'll verify and the.
What?
But no, that is the.
Sarpanch cannot. That's what we have.
You are also an organ of the Constitution, sir. When a Panchayati Raj is included within the Constitution of India as one of the integral part, tell us, you are the constitutional authority. Are you not? No.
Give it at the moment. One cup.
Only cup.
Because collector,
It goes out of the.
no, my lord, in fact, collector has called for the report. The record project be included. So we are not blocking the work. The collector on our complaint is attended to by the collector. He is saying the record project are left out. So the on-record project are giving approach.
So locus. What is your locus? Is the first thing foremost. Go through the judgment, but what is your locus? No problem. Then we will enter what is there and what is not. What's the locus? 1 week or
One cup. 9 months.
yes.
30th of June.
That's it.
9 months. Item 10.
The place where the vehicle was seized after 4 hours of the expiry of transit. It's the lordship of taking instructions and file a detailed form to your lordship. Yes, your lordship, the fact is that each time a vehicle is loaded, it is inspected, and at that point of time, a transit pass is issued with the time frame.
Correct.
The time frame relates to the distance it has to cover.
Correct.
Here, it was a distance of about 25 kilometers.
Do you have all the mechanisms of anticipating or foreseeing any other things while they are, may I use the word, they're embarking a journey on the road? There may be
Your
some
lordship,
protest,
if
there may be some protests, there may be some processions.
They have-
There may be some cattle who are, I think.
Under GST, they will have the same problem. Mr. Mishra, there is some decisions.
they have to give it in writing, your lordship.
Relaxing the time period, validating the time frame of this waiving.
Yes, your lordship.
Student transit. Transit delay, that is condoned by the department.
Provided they approach your lordship. And the driver's statement is also there that I did not have a transit pass. And these vehicles, I did not have a transit pass. The driver has said that statement is also there, your lordship. I have to file a detailed counter, your lordship. And the fact is that these vehicles, they go to and fro, your lordship. They load, they go, unload, they come back, again they load, and then they go.
Correct.
Your lordship. So this was a transit pass that was in the morning, your lordship, 4 hours. It takes about 30 minutes, so they have given the period of 1 hour. And if they do not fly that vehicle in that particular hour, then they report to those authority there, your lordship, at the loading site, that we've not been able to take the vehicle out, and so, your lordship. So the transit pass is again given.
That they have 2 trips, which their transit pass has not been checked into.
No, this is a transit pass that gives the time is mentioned, your lordship. This is
Complete your voyage. He has completed at least 4 hours late. That's all. So every time when it is done, the separate transit pass is.
yes.
But he's talking about that transit pass. So she cannot take a plea that that was a second trip or a third trip. And she cannot.
Unless goods are.
Honorable Allahabad High Court as well as Madras High Court have passed several judgments and your lordship. The government and department has to prove that this is a second trip.
Just the department.
There was no unloading of the goods there.
I understand, madam. That is why she wanted to project in a manner as if there was some,
Separate. Yes, no,
you know, the underarm things which really
Your
went
lordship, I have
on.
to get those
Not
facts.
case, yeah.
Also not the allegation in the demand notice. Sir. I have to get those. I have to file a reply, your lordship.
The TANDON bus. The Excel, which is where the was broken. Okay, so multiple reasons. What is the total amount of the penalty or fine, whatever?
2,08,911. 2,08,911.
Secure the amount.
Secured amount.
Secure the amount. You wanted a release of the vehicle.
Yes, Your Lordship.
Give some security. We'll pass the interim order. Release.
Penalty is 2 lakhs, royalties, 2,000.
2,000.
Royalties 2,000 and environmental compensation 6,000.
Yes, sir.
How can you secure the amount?
Your Lordship, the instrument. How much amount?
Deposit here. Deposit here.
Subject to.
We'll see to it.
Pleasure.
Give a security, anything equivalent to the amount, no difficulty. You can give a bank guarantee, no difficulties. Give that.
Bank guarantee,
Bank guarantee.
can you furnish bank guarantee? Of this equal amount of this entire amount. 2,08,900.
You need not have to pay them, but give a bank guarantee so that.
Yes, Your Lordship. I'll-
Secure.
To petitioner accordingly.
Come tomorrow,
Yes.
tell us. Tomorrow, keep it tomorrow.
Item 11.
Bank guarantee or any form.
Any property fetching more than 2 lakhs rupees value, no difficulty. Or place a fixed deposit. No difficulty.
Item 11. The petitioner is challenging Rule 12, Sub-Rule 1 of Orissa General Financial Rules of 2020.
Then the Advocate General has to be given a notice.
Why not? Here, I just
Is a-
want to. Yeah, may I not?
Is a virus challenge,
Yes, my lord.
then the Advocate General is entitled to notice. So you'll have to give a notice.
My lord.
Give a notice. D'accord. The virus of Rule 212 within bracket Roman 1 of the OGFR 2023 is challenged in the instant with petition. As the same is neither consignable nor strictly in tune with the constitutional and other statutory provisions. Stop. The petitioner is directed to serve a notice upon the Advocate General as the virus of the provision of the State Act is assailed in the instant writ petition. The writ petition is returnable after 2 weeks, given a notice in that come back. Yes.
Thank you, my lord.
Item 12.
Your Lordship, this is a public interest litigation in respect of a land acquisition that happened 18 years ago.
Huh?
18 years ago. Now, this was for a private company. The amount of land that was acquired was 5,111 acres. Now, what has happened is over.
Under Act 1 or under
The older.
Act 1?
Yes, Act 1. Now, what has happened is, my lords, 18 years have passed and most of that land remained unutilized even till today. I've attached photographs by the cultivators because I'm from that village. They're cultivating the land. and it shows that,
Once the acquisition proceeding is there and they have, the collector has deposited, then it vests into the government. Can it be
yes, now,
reverted?
my lords, what has happened is under
There is
101
one or two judgments of the Supreme
Yes,
Court which says that once vested cannot be divested.
Yes, but my lords, now will also consider 101 of the new Act, Act 2. That says that if compensation or possession is not taken, then it goes under the new Act.
That is section 24 Indore,
24, yeah.
Indore
Indore
development you are
Authority.
talking about.
And then, yes,
But that has to, that's a factual aspect. We have to look into it. It
yes,
cannot be
that's
done.
what, because my
It is
lords,
that Act 1, the Land Acquisition Act of 1894 or something.
1894. And my lords, just from the Act 1, my RTI replies show that they invoke the urgency provision under Section 17 in a very cavalier manner.
That is a
I'm not pressing that, my lords.
again, it will create it will open a very big Pandora box for that.
But my lords, now what has happened is this. Now the RTI documents that I've got show that 2,500 acres are utilized by the company. There is no account of another 2,000 acres, and they say 500. This is 18 years later. 500 acres are yet to be allotted. Now, how is it that, a company gets 5,111 acres and there's no accountability how that land is being utilized? All I'm asking, my lords, in this public interest litigation is that there's an inquiry into how this was done. You can't have unutilized land. As my lords has rightly pointed out, Indore, the DDA judgment, which relies on Indore, says that if the new acquisition then applies, 101 says excess land has to go back. Goes back to IDCO or the landowners.
Look at section 16 as well.
My lords. When the collector has made an award under Section 11, he may take possession of the land, which thereupon shall vest absolutely in the government, free from all encumbrances.
So once they have deposited the compensation,
Yes.
after determining the award, determining the market price of the land, and then in that event it vests. The once it vested, can it be divested subsequently?
Now, my lords will also now look at the new Act, Act 2, 24 and 10001. Now, 24, my lords, of the new Act, Act 2.
Because 17 is an emergency provision.
Yes, which they invoke in a very cavalier
Yes.
manner. for this company. Yes. Very good. Now, if my lords have 24 of Act 2. Does my lord have Act 2, 24-2?
Give me Act 2. Right to Fair Compensation Act of 2013, I believe. Section 101.
101. Return of unutilized land, my lords. When any land acquired under this act remains unutilized for a period of 5 years from the date of
But
taking
this
over-
was, if the land is acquired under this act, it was acquired under the old act.
Yes.
So how 101 will apply?
Well, now my lords will read 24(2). If I
Yes,
could
it
just
says
remind
that
you-
if the compensation is not paid,
or
or the
possession not
possession
taken.
has not been taken, then in that event, it will be deemed that the acquisition proceeding which was initiated under Act 1 shall lapse. That is a different. Then there were a divergent of opinions.
My lords.
Now the matter was referred and ultimately it is set at rest. So the moment the award is made under Section 11, then it will be deemed that the position under Section 16 of the Act has been taken by the government. Once the land vested into the government, it can only be divested by a fiat of law. It cannot be divested of its own. Show us. There's an interesting question. I believe
So, my lords, I'm
no further deliberation is required. I think it is set at rest now.
No, my lords, but as far as the utilization of the land,
There is nothing under Act 1
Yes, my lord.
that the surplus land has to be returned. There is no provision in Act 1.
But my
It
lords,
has come up
Yes.
and it says that if it is acquired under this Act, if after 2013 the acquisition has taken place
yes, my lords.
and it appears that there has been a surplus land and which is not required to be utilized, then it will be reverted to the owners. The government may under Section 101. But what about the Act 1 acquisition?
No, but that's exactly.
Can you,
Yes.
after Section 5 is over, can you say no public purpose?
No, but my lords, now we go back to that Section 17. When this acquisition happened 18 years ago, they in a cavalier manner invoked Section 17. Now that
Did you
RTI
challenge that?
No, we
Section
don't-
17, you did
No,
not.
we do not challenge that.
So
So no one. Now, my lords, why I'm here in public interest is 5,111 acres is at stake. Now, if my lords would see page 73, these are all
I
RTI
understand.
documents.
They could let us proceed on a very undisputed manner
My lords,
that they acquired 5,000 acres of land. They could utilize only 4,000 acres of land.
my lords,
1,000 acres remains surplus.
my lords.
Now, can under Act 1, the owners of the properties say that it is unutilized land should be returned because it is no longer, the public purpose no longer subsists? Can you? I'm asking this very simple question.
No, so if my lords would examine this question, because what if my lords would see page 73, just for a moment. Now, 73 is an RTI in 2024, which says that out of 5,111 acres, 504 still remains to be.
Correct. I'm saying, I told you, suppose it remain unutilized, it has not been utilized for public purposes.
No.
Then under the Act 1, is there any provision for return? Whether the Act 2 of Section 101 will apply automatically?
Yes, but my lords, my humble
That's
submission is that
a big
24
question. That's a big
So if my
question.
lords
You
could examine.
satisfy us.
So if my lords would issue notice and then that's it, because my reading of 24 read with 101 is that 24(2) says if under the old act you have not paid compensation or you've not taken
But
possession.
here is a case, it was, they have taken that it was a case of a payment of compensation two ways.
Yes,
One is that collector, after ascertaining the market price of the acquired land, if the owner of the land does not come forward and take it, then he can deposit with the court. And then if there is any Section 18 references or a reference under Section 30, I do not know. There is two kind of a references. One is when you're disputing the quantum of the compensation is Section 18, and when apportionment is disputed, then I think it comes under Section 30 of the Act 1, probably.
Yes. Now, my lords, my concern
So in that event, if the moment the deposit, because the initial judgment in Indore development was that whether paid means it must go to the owners.
Yes, my lord.
Then the later on, there was a doubt which was created and ultimately it was held no. If the compliance under Section 11 has already been done and the word is used as disjunctive, then the presumption under Section 16 will arise immediately. because the position is taken.
Yes, ma'am.
Then in that event, you can't fall back.
So-
And section 24(2) will not apply.
But my lords, my contention is now the clarification given to all the collectors were when land acquisition is done under the old act and when award has been made 5 years or more prior to the commencement of the new act, but compensation has not been paid.
Paid. This is what I'm
Or-
saying. The paid word.
Now,
Paid means it is paid to the owner, or if they deposit
But
the
my
amount,
lord-
whether that amounts to compliance.
But my lords, there are two pillars of this. One is whether it's paid or if physical possession has not been taken.
This is what I'm
On
saying.
the second
Now again, a physical possession and the possession in a symbolic manner.
Now, my lords,
The possession has a different facets.
would my lords,
There may be a
because
physical
I have to
possession,
do-
there may be a symbolic possession.
My lords, all I'm asking is for an examination by this court saying that I've attached photographs where the land users are cultivating the land.
I
So there's no
understand.
compliance, my lords.
That's a
At least-
symbol. That's why I'm saying if it is a symbolic possession,
My lords, because the government has not disclosed any documents, we
Well,
don't know
it is-
whether
it is already
possession is
there.
actually taken, symbolic or otherwise.
must be there after section 11 immediately.
My lords, at least call on the government to disclose. All I'm asking is for disclosure that everything has been done correctly. That's all. Just accountability. You can't just acquire 5,111 acres. Everything remains unutilized. The landowners are still cultivating. I've attached photographs there. And there's nothing. IDCO doesn't provide any utilization certificate, any performance audit, which it's bound to do under Section 34. All I'm asking is for accountability. Let at least the judicial conscience be satisfied that everything is in order. That's all I'm asking, my lords. It's not that the authorities just keep mum, don't disclose anything, and have been filing RTIs after RTIs, nothing. What has happened to that land?
Yes. Yes. What do you say?
Instructions are not shown.
Any Odisha amendment has been done. Those processes. Any Odisha amendment is there in Act 1?
Not that I'm.
I have also not come across. Was there a reference under section 18? Yes. Was there any reference under section 18?
My lords, I don't have any information on whether there was a reference or not.
Has to be.
It should be. And there also, as far as the R&R scheme, the 400 families that still have to be resettled. And I've taken that in my public interest petition. My lords, everything is opaque. We don't know what has been done in this case. We just want some accountability, my lords. And that will only come if my lords examine the matter. Otherwise, this whole thing is swept under the carpet.
Yes. What to do, madam? He's talking about lapsing of the proceedings. Then the entire thing will go. Which I have to disclose that everything was followed. They sat over the right. If the award has already been made by the collector, money either paid or deposited with the court. These are the only facts which I want. Then I will consider that section 24(2) of the Act 2, how far it can be. Which I believe is a very humongous task for him. Very difficult, sir.
But my lords, if we could just...
Very difficult. Sorry. How soon?
4 weeks, Your Lordship. 4 weeks.
A point is raised in the instant writ petition in relation to the applicability of section 24 and section 101 of the right to fair compensation and the transparency in the land acquisition, Rehabilitations and Resettlement Act 2013, vis-a-vis the proceeding initiated under section 4, followed by proceeding initiated under the Land Acquisition Act 1894, which on the face of it culminated into the partial utilization of the land for public purposes. According to the counsel for the next one, according to the counsel for the writ petitioner, the quantum of land which was a subject matter of notification under section 4 of the Act of 1894 has not been utilized fully, which would be evident from the information furnished under the Right to Information Act. which ipso facto lead to a presupposition of law that the said land is no longer required for public purposes. And therefore, in view of section 101 of the Act of 2013, it is obligatory on the part of the government to return the said unutilized land to the respective owners. It is further submitted that since the awarded sum was not paid to the owners, nor the possession, nor the physical possession was taken in respect of the aforementioned, in respect of the said unutilized land, the proceeding under section the would automatically lapse by virtue of section 24 within bracket 2 of the Act of 2013. The next matter, the core issue involved in the instant writ petition is whether the Act of 2013 has any manner of application in relation to a acquisition proceeding which was completed under the Act of 1894. Full stop. Whether unutilization of a portion of the acquired land which vested to the government is liable to be divested into the respective owners under the provisions of the Act of 2013. Stop. The Council for the State prays for an accommodation to take an appropriate instruction, more particularly whether the compliance to the provision of Act of 1894 was strictly adhered to, and the acquisition proceeding resulted into a logical end, resulted into a completion by achieving the logical end. Stop. How much time you? How much? Let the matter be listed after 4 looks.
21st of July.
Was very difficult, sir. Very difficult.
We'll do some more homework. Obliged.
Item 13.
So, petition by the labor contractor, selling the issuance of initial
Yes.
The petition by the labor contractor,
Is a labor contractor.
my lord,
Yes.
is selling the initial fees that is issuance of work order in favor of OP number 5 on 2 grounds that the service charges quoted by the selected candidate is 0, which is against the minimum service charges, and there is error in the calculation of the financial bill. Let's say kind of a glance to page 27 of the page. Let's see that is escalation clause. If minimum wages increase during the period of engagement under minimum wages at 1948, the basic rate in the statutory contribution shall be increased pro rata basis. Accordingly, the service or agency charges within bracket minimum 3.85% and maximum 7% of the job rate will be remain constant. Therefore, let's turn to next page. That is the illustration within bracket sample for calculation of quoting rate. And the service charges, the absolute amount is 0.04. Now let's see, kindly have a glance to the rules which prescribes the service charges. Let's see, that is at page 50. That is rule 64 to 64 IV of the Odisha General Finance Rules Manual. That's my permitted read.
Page 50.
Page 50. Evaluation of the bids received with heading 264.
Yes.
Surplus IV. The minimum rate of service charge shall be 3.85% within bracket 3% of profit plus transaction charge. The procuring entity may also fix the service charge above 3.85% with proper justification whenever required, provided that the service charges should not exceed 7% in any case. And pursuant to this tender call notice, 8 bidders submitted their bid, including the petitioners. They were qualified in the technical bid. They were called for the financial bid, and Lordship kindly glance to annexure 4. That is the pro forma prescribed by the tendering authority for submission of final bid. Lordship straight away come to page 57. Page 57 of the brief.
Yes.
And serial number 20, my lord, that is ancillary job pertaining to production of lossy within bracket seasonal as per detailed tender call notice terms and conditions. Quantity 4,000 pounds, and the basic rate which is quoted by the selected candidate is 0.09 paisa, and total amount is 3,600. Now, lordship, the very important, the 21, column 21, H for above item, but for service charge within bracket absolute amount, minimum 3.85% and maximum 7% of job rate as per item 20, he has quoted 0.00. That is my case, my lord. So when service charges is quoted 0, and the circular rules says that it should be minimum 3.85% and maximum 7%, and the DTCN also prescribed that it should be 3.5% service charge.
No, I do not know under what column this 0 has come.
My lord, 21.
No, under what column? That is the first schedule. That's the column of a basic rate.
Basic rate.
So where is the service charges?
Service charge, column 21, my lord.
Oh, that is, it is not, it simply say for 40,000 pouch. And
my
then
lord,
00, I do not know what is this. This is a basic rate part. Where it says that this column,
my lord,
that is the third column,
my lord.
it relates to service charges.
Yes, my lord.
Where do I get it? I just wanted to know.
My lord, lordship, serial number.
Because at page 56, if I go, one is a serial number, another is item description, third is a quantity, approx volume of the work per day, then the text is units, and then the basic rate. I do not know.
Sixth column. Column number 6, my lord.
Column number
6. 5 and 6, quadrant.
That is basic rate.
Basic rate, basic 0.00 and total rate 0.00.
But that is a basic rate.
And my lord, 6 column also 0.00. It cannot be 0, my lord. But the guidelines rules prescribed, it should be
minimum 3.85 and outer cap is 7.
Yes.
Understood.
My lord. And he has quoted 0. And so far as the other point is concerned.
What is this? Still, we are in confusion whether it relates to this. What is this, madam? Who is appearing?
This is ballot of the federation ballot from 1 to 4.
Lordship,
no, tell me what is this? Can you give a clarification on this?
I can give a comprehensive affidavit ballot if you lordship.
What comprehensive? Just
this explanation
enlighten us whether this basic rate, that's the number, serial number 6, and then the serial number 7 is total amount of taxes which is given. I just wanted to understand that what is this? Is it a service charge or what?
This is the bill of quantity one has to submit in form of the bid ballot, where the commodities are mentioned in item description.
Yes.
Because he is a labor contractor for certain jobs, my lord, he has to specify the basic rate and the rate of service tax, which is statutory deposit.
Yes.
And also the sixth column, my lord, that's what he is hinting at, that is, my lord, absolute amount minimum 3.85 to maximum 7% job rate, my lord, on the rate of basic charge. His apprehension, my lord, because it is indicated 00, his entire case.
But I do not know whether this first, this is the name of the bidder is Mohan Kumar Patnaik.
Yes. One who has secured the contract, my lord. Now,
Has he been served?
Work order has been
Already, has he been given a notice?
First time it has come, my lord.
So he has to be given a notice because the work is awarded to him.
Another my point is that Dr. kindly look a glance to page 53. Page 53, column number 3. That is, they have quantified
9.9, 9.09.
page 53 and step 4.
Serial
Serial number 3, 2. And
serial number 3 or 2?
My lord, serial number 2. Ancillary job pertaining to collection of milk pouches as per retention terms and conditions.
Correct.
50,000.
What is this TLTR?
That is thousands liter. And so per thousands liter, I have quoted 236 rupees. So, Lordship, if 1000 liter per 1000 liter the rate is 236. So 50,000, it will multiply into 236, it will come to 11,800. But they have quantified 1 crore 18 lakhs. That is erroneous calculation. And so far as selected bidder is concerned, he has quoted 0.24.
This is your document. You have submitted it.
My lord, so far as selected document also, there is error. That I have annexed, my lord. Page 56.
Sir, 50,000.
My lord, if
What is this TL?
TL 1000 liter.
1000 liter.
1000
So
liter.
what is the price? You have quoted a basic price of 236 what?
236 per 1000 liter.
Per 1000 liters.
And
But
if you
that is not indicated.
Well, the basic rate I will, unit is TLTR. 1000 liter basic rate 236. If we multiply 236 into 50, the amount goes to 11,800.
What are you talking about?
My lord,
It will go to, because you have to multiply with 50,000.
well, 1000 if 1000 liter to 236, then 50,000 means into 50.
How do I get it that you have calculated it as 1,000 liter?
My lord, they have mentioned TLTR 1000 liter. Unit is 1000 liter. Unit 1000 liter is to take as a unit.
The confusion. Whether it is for 1,000 liter or 236, that's the milk
My lord,
pouches. Of what volume?
that is the basic rate
I am asking, sir, of what volume?
of 50,000 liter.
Sorry?
Of
Pouch of what volume?
pouch of half liter. One pouch contain half liter.
Half liter.
My lord.
And half liter, and for 1,000, 236. Who can give? In a market, the milk for 1,000 liter will cost 236 rupees. I just wanted to wonder where.
And my lord,
I think every member of the bar will be very
and my lord,
interested to buy.
My lord, interestingly, the selected candidate code 0.24. Then 0.56. The selected candidate code 0.24.
Is this?
It is job contract, my lord, for transportation and collection of.
Oh, that is what I am saying, sir.
0. I have quoted.
His entire case is based on surmises, my lord. I can clarify it.
That is what I wanted. He is
Arithmetical calculation
trying to create a confusion.
Arithmetical calculation is also wrong. Page 53 is his own document, which he filled in, my lord, that bill of quantity, which is part
This
of.
is 1,000 liter. 236 rupees for 1,000 liter of milk. What are you talking about? For carrying.
For carrying only, transportation. For carrying.
Transportation.
This is only towards labor cost of.
And I have quoted 236. The personal
Nature of work, total nature of work.
No, 6.
Column 6 or item 6? And the 00 figure he believes is 00.
No, The secret includes service element.
No, that is why they have to be added further. Not to put the interest of the bidder, my lord, in adverse.
Service charges is to be charged on the basic rate.
Basic he has to indicate. Thereafter, what are the service charges, what are the statutory deposit, those are prescribed, my lord. And that has a minimum limit and maximum limit.
He has quoted 0.24. Yes, true.
Only
24
where-
paisa, and he has quoted 236 rupees.
Just imagine, my lord, and he challenges selection of OP5 on ground that he indicated in his service provision 00,
And
which
that
is also
his
based on
calculation-
premises.
the
Confusion,
calculation,
my lord.
mathematical calculation is the same
Yes.
for him. No.
Now, after giving in writing how much money you want, he said that is arithmetical calculation. Arithmetical
But
calculation.
arithmetical calculation will also be applicable to the opposite party number 5. Same way,
I'm agree,
same way.
Everyone.
So it makes hardly any difference. Because if he has quoted 0.24 paisa, means 24
24
paisa,
paisa, my lord.
and he has quoted 236, whatever mathematical calculation you do,
Exactly, my lord.
he is much higher.
But
straight
much
away.
higher, my lord, obviously I am not selected. And he is
Definitely.
challenging on ground that he did not indicate
The service
how
charge-
much service charge that and
And that is the basic, my lord.
basic. Now,
That bid is irresponsive bid. And my lord,
I will answer to that also here, my lord. So far the face of the document. My lord, that
No, I know that there is a judgment of Justice, I think, Justice Saran.
my lord, lordship, I am giving you lordship consent, the office memorandum of the finance department.
No, there is also a judgment on this point
Yes.
of a division bench.
in course of evaluation of the price bid, my lord, that came to the notice of the authority that there were many small errors committed by bidders. That was ignored. In fact, on this ground, the bid of the petitioner was to be rejected first, my lord.
Yes.
Because he has given how much, my lord? There is a limitation. 3 point.
No,
Just allow.
he's happy if his bid is rejected. But unhappy that others' bids cannot be accepted.
Cannot be accepted if the service charge is actually 0.
That is the main motive.
Correct, man.
That if I go, then I will let others to go.
And his continuity with the establishment is still first of coming month, my lord.
This is continue his
And OP5 has already meanwhile deposited the statutory.
the work contract work order has already been issued.
Which he has included, my lord, page 63. Your lord,
So
kindly
it
very
is
good.
issued, no difficulty. You file your affidavit and giving a notice to the respondent number, the opposite party number 5. Because he will be the person who will be affected by this. Is the person.
And
Notice on opposite party number 5. And counter affidavit by 3 weeks.
Ma'am.
You file. Opposite party number 1 to 4. Since the work contract has already been issued after finalization of the tender, and therefore we do not find that it is a fit case where the petitioner is entitled to any interim protection. Accordingly, the prayer for interim order is refused at this stage.
Lordship, may I permitted one sir.
Yes, call the names.
Lordship, any agreement. subject
Item
to
14.
Application.
Next.
Mr. Fernando?
One to four. 1 to 4. Hurriedly, I had to file the Vakalatava for rupee 1 with the
Item 14.
Then annexure 1 is the include order, page 18. My lordship, please to turn to page 18. Annexure 1. So let me tell you, lordship, what is this case about? My lord, I am a lessee of iron ore, and the state is the lessor. Under section 206 1C of the income tax law, when the seller can be the state lessor and I am the buyer, when they sell any ore to me, what I do is actually in lieu of sale price, say pay royalty, DMF, DMT, all those statutory dues. So every month they are supposed to collect a certain amount of TCS. It is like something like TDS. TDC. This is called tax collected at source. And whatever they collect, they deposit to the treasury, to the central government. And they give me a certificate. Now here what has happened, if your lordship sees minutes, here the demand is for the year 2021, 21, 22 and 22, 23. In all these years, assessment is already over, so far as I am concerned. And I'll give your lordship an illustration. If my lords kindly sees page 19 for a minute. My lords have page 19. Yes. Your serial number, PAN, name of the SSC, your lordships have that. And then head of account. What are these head of accounts? Application fee, user fee, payment charges, NME fee, upfront payment. But what is upfront payment is when we take it on auction, we make some upfront payment. And if your lordship goes down, it also says, my lords, application fee, royalty, user fee, payment charges, NME, DMF, etc. Now, before your lordship go further, kindly have a look at the scheme of the act. Let's see, to section 206. This is 206C. Your lordship may see, it says collection at source. My lords have DP at the top. Collection at source. Profits and gains from business of trading in alcohol, liquor, forest produce, cap, etc. etc. Your lordship may kindly consider as mining. And my lords may kindly be pleased to turn over the page 1C. Because mining is what we are concerned with.
Nature of the goods given in the table, the last one is the Roman 7 also talks about the minerals being to.
Yes. So my lords may, your lordship may kindly turn over. There is a more specific entry at 1C. My lords are pleased to have 1C minutes. Now kindly see minutes. Now if your lordship sees, I'll come to the table, mining and queries, Roman 3. I'll read the section just for your lordship's convenience. Now let me read this. Every person who grants a lease, your lordship may take it to be the state government, enters into a contract or otherwise transfers any right or interest either in whole or in part in any parking plaza. We are not concerned with that. Toll plaza, we are not concerned with. Your lordship may next see it's mine. This is a mine and not a quarry. My lordship only take mine to another person other than a public sector company. So that is exempted. Hereinafter referred to as licensee or lessee. Your lordship may note, I am a lessee. For the use of such amount, for the use of parking lot, or, toll plaza or mines for the purpose of business. So here I am using the mines for the purpose of business. Shall, now your lordship may kindly see, shall at the time of debiting of the amount payable by the lessee into the account of the licensee or lessee, the lordship may read as lessor, or at the time of receipt of such amount from the licensee or lessee in cash or by issue of check or draft or by any other mode specified in column 2 of the table below, sum equal to the percentage specified in the corresponding entry of column 3 of the said table. So therefore, whenever I am paying them anything in lieu of mining, they will at that point of time, my lords, collect from me 2% of whatever they are receiving. My clear, my lords? So therefore, onus is on them to collect it. Now kindly see, my lords. One more provision, lords, you may kindly see 3. And that is that page, my lords. Over the page, 4 by 7, the page is at the bottom. Kindly see subsection 3. It is at the top. My lordships have it, my lords.
Which page?
It is, the pagination is at the bottom. It's called 4 by 7.
Yes.
You kindly see subsection 3. Any person collecting any amount under this section, therefore the lessor, the state, shall within the prescribed time, the amount so collected to the credit of the central government or the board as the board may direct. So whatever you collect, you pay to the central government. Now kindly see 4. Any amount collected in accordance with the provisions of this section and paid to the credit of the central government shall be deemed to be a payment of tax on behalf of persons from whom the amount has been collected, and credit shall be given to such person or any other person eligible for credit, we are not concerned with that, for the amount so collected in a particular assessment year. Kindly note, my lord, in a particular assessment year, because these are all in relation to an assessment year, in accordance with the rules as may be prescribed by the board from time to time. So whatever you collect, give me a certificate like TDS. Kindly see the next one. 5. Every person collecting tax in accordance with the provisions of this section shall within such period as may be prescribed from the date of debit or receipt of the amount furnished to the buyer or licensee or lessee to which account such amount is debited and from whom such payment is received, a certificate to the effect that tax has been collected and specifying the sum so collected and the rate at which tax has been collected and such other particulars. So you collect at the time if you receive. Once you collect, you give him a certificate after making the payment to the government. Now kindly, my lord, see 6. Oh, the next page. Subsection 6.
You understand that
Yes.
if they fails to collect in accordance with those provisions,
Correct.
then in that event, they have to pay to the credit.
That's the proviso there. Your lordship may have 6. Your lordship may see 6A proviso. There's a 6A proviso. If I have complied, then they have no problem. That's the point. Kindly see, my lord, proviso to 6A. Provided that any person responsible for collecting tax in accordance with the provisions of subsection 1 and subsection 1C, who fails to collect whole or any part of the tax on the amount received from the buyer or the licensee or the lessee, or on the amount debited to the account.
So he will not be treated as a defaulter.
He will not be treated as a grateful. I'm grateful to you.
He will not be.
Yes. Now kindly see, my lord, what are the facts of this case? My lords may see, page 18 is what I showed you, lordships, annexure 1. I'm sorry.
Subsection 8.
Yes, please. Not where the tax has not been paid as aforesaid. After it is collected, the amount of tax together with simple interest thereon referred to in subsection 7 shall be a charge on all the assets of the persons responsible for collecting the tax. That will be subject to the proviso to 6A. Therefore, under the scheme of the Act, it is for the seller to collect the tax. However, if the buyer has paid his taxes, then it is absolved under 6A from any penal provision. Now, kindly look at the facts of this case. Page 18, they are seeking to collect carrier tax much after my assessments are over. Now, let us see, this is not the income tax department. This is the mining department. It is now saying that, look, you pay for the past 3 years, which they should have collected. Now, kindly see, Your Lordship may see page 22 and Your Lordship should after lunch or something.
Yes.
Lordship may see here now after lunch. Whatever it was.
Yes, what it says?
Yes, kindly see page 22. Page 22.
Now they have deposited.
I have deposited everything.
Yes.
I have been assessed. I have got a refund. So therefore, nothing really survives.
Assessing default.
I cannot be an assessing default because I have paid, I have been assessed, I have got a refund. Now, why will I pay you? Again, there is no question of me being again assessed. And kindly see the refund that Your Lordships will see straight away at page
52 and 59.
Kindly see page 52.
Annexure 3.
Annexure 3.
Suppose if it is collected,
Yes,
it is also an excess amount because already they
My point is, this. What is this?
TDS.
The whole scheme is.
You are entitled to that benefit of.
Correct. The point is this. I'm grateful. What that is falling for Your Lordships. Had my assessment not been completed,
This is a different.
yes, here it has been completed. I have got a refund. Kindly see, my assessment order is at page 51, annexure 3. And at page 59, I have already got a refund.
When the assessment has already been completed.
Yes, Your Lordship may see 51 is the assessment, is the return. ITAT return.
When the order.
Yes. Kindly see page 59. Acknowledgement of the return to the self-assessments.
His date.
Yes, kindly see page 59. The acknowledgement of the return. The page annexure 51 is the return.
We have to scroll several pages. What is the date?
The date of the return.
No, the assessment order.
These are self-assessments. These are IT returns. Kindly see page 51.
That is
Yes.
139.
And my lords may kindly see page 59.
Where is the adjudication?
Page 59 is my return.
Where the entire return has been processed, the IPR has passed, accepted it by passing an order and referred. For the dates, it must be an order, assessment by the authority.
I'll file the assessment orders.
Assessment order.
I'll file the assessment.
When that was done.
All the 3 years assessment has been done, I'll file the assessment orders. The question is this: is the liability on me?
You wise.
Lordship, we don't have any.
No, I have nothing to do with the income tax department. Let me put it.
How they are making you as a.
No, let me ask myself a question. Would Your Lordships, 2061C. The liability is on the seller to collect, not me. If I have
You
paid.
made the income tax as a party here, your remarks was only against.
No, no. They are a pro forma party. Kindly see, Milords.
But they are entitled to appearance. Now everything has come to them. What they will do, you don't know.
No, Milord, my submission is this. Under section 206C.
I understand everything.
Who is to
There
collect?
are other sections
Yes, Milord.
where
No, doesn't matter. No. Milord, the liability to collect is on the seller.
I understand.
Yes.
I understand.
Correct.
So your remark was against the seller,
Against the seller, not against him.
but you have made them a party.
I know. Milord, we will delete them.
No, don't do it. Yeah.
That doesn't matter. Doesn't matter. But I was only saying this.
What will happen in future?
Milord, I was only saying this. If your lordships accept my submission.
Yes, how?
For Union of India.
No.
Mallet,
Who is a lessor?
Mallet, I appear for the
So
state
what,
of.
how?
Mallet, the duty cast upon the seller to
If you have not, then in that event what?
here.
Because after the return is finalized,
Mallet, if I'm only
the
referred,
assessment has already been done.
Mallet, if I only.
View of this provisions of the act.
Yes, Mallet.
And look at section 6, subsection 6. It's very clear. If they fail, the liability is on them. They can only absorb if I have paid. Kindly see Milord subsection 6 at page 5 by 7.
Because he has already paid the tax, or rather he is entitled to a refund upon the adjudication from his ITR.
My lords, if I may refer to the notice, my lords, here we talk about only the arrear applicable, even if it's for the prior year, my lords. It has to be 2% as per, and the collecting agency, as per the act.
Why under the income tax act? Why this provision was there that if the person responsible for collecting the tax in accordance with the provisions fails to collect the tax only or partly, then in that event, there is some certain embargo which is created.
I'm grateful.
on you. If it is an embargo which is created, maybe it's your fault. Why you will make them liable because their return has already been processed. Everything has been done for that financial year. Can they get an advantage of this payment of the tax for the ensuing financial year? I'm asking you.
My lords, if I may.
If they can get an advantage of this tax payment, no difficulty. I think they will be very happy. They will pay. But must get for this financial year, they must get the advantage.
My lord, I'll take instruction, my lord, because in the notice itself, there's reference to 2 orders, my
The
lord.
problem is because they cannot get the benefit of it. Not uploaded in 26 years. Because you are not paid. How can they take advantage of the tax liability saying that I have already paid this much, my liability is up to this much, deductions, and then make the payments. Can they get the advantage? Shows the
Yes,
law.
I'll take instruction.
Shows the law that they can get the advantage of this payment for this financial year. Continuing. No problem. How? 1 week time? No. 1 is enough. Don't take courses.
I'm grateful to you.
Now.
I'm grateful.
Yes, simply adjourn, but convey that don't take courses.
30th of June.
1 week next week.
30th of June.
30th June.
Sir, can you give 1 week after that week? I'm not.
Any?
I will talk to the court.
Correction, connected by the same.
Yes, same.
Yes. My call for finish. Item number 15.
On behalf of Miss Ipti Party, I pray for adjournment. She has some difficulties, therefore she asked for adjournment.
30th of 30 June. Item 17.
The vintage may be tagged with 47, that non-existence of tribunal, constitution of the tribunal, 10. Some of the matters have been listed at item 47. Yes, order has been passed here. So let it be tagged with 47.
Yes, it may be tagged with WPC number 9822 of 2025. No, that order has already been. Order has already been passed. Yes, ma'am. It is only to be tagged with that. Yes. That matter is there in item 47.
Item 18.
Will also kindly permit to withdraw this rate application to file a better application. To withdraw this application to file a better application.
Item 19.
Item 19 may be taken up along with item 45.
This matter is similar to item
45 may be the lead matter, that readings have been completed. So this is that 168 that limitation. Your lordship. So 45 is the lead number. Let it be taken up along with 45.
There is an attachment in this message, so I have just made the necessary corrections in this way. Uh, 45 minutes.
Item 20.
Yes.
21. Item 21.
Cancellation. Cancellation.
Item 22.
This matter relates to cancellation of registration.
Item 23.
Rising out of the service matter, the Lordship had heard me in this, and the Lordship wanted to see the validity of that first aid certificate. Lordship wants the including orders at Annexure 5, page 24. 2 points we are raising. One is the certificate was not valid, and the 5 lakh cost that has been imposed on this. So on the last occasion, the Lordship wanted to see that 3-year period from where it is comes. So the certificate itself has that 3-year thing. The Lordship would see the certificate given by the writ petitioner. In a memo, we are giving that it's a part of his application. This is to certify that so and so Keshav Chandra Sethi. I have just given copies today. Yes. If your Lordship sees that St. John's Ambulance is the organization which gives the certificate, and the date is mentioned, and just below that table it is mentioned that the certificate will be incomplete if so and so has affixed below, and will become invalid unless he/she
is re-examined within 3 years from the date of his exam.
2010 expired.
Yes. So that was our case. But in this case, if your lordship would recollect what has happened, page 24, the basic facts are mentioned.
When the application was filed,
It was a recruitment.
is what is last date of submission of an application?
Was the last date was, my lords, May 2016. And then we gave a letter that since you have given an invalid certificate, kindly come with a fresh certificate. And that letter is something which the court, the Honorable Single Judge, took as an extension of time.
Where is that letter?
That is after the cutoff date of the advertisement. That would be annexure 2, page 17.
Yes, we have extended the time for 15 minutes.
My lords. So this letter is something which is against us. And after this, he gave a certificate which is at annex at page 19. Which is basically a certificate of participation. But here your lordship had pointed it out against me that because of MS Gill, because this was not something which we had given in our rejection order or even before the Honorable Single Judge, this is not a point. So
This certificate is given to you on 4th May 2015.
21st May 2016.
Page 19.
4th May is the date of the certificate. Forwarded the previous page, page 18, the writ petitioner gives the date, 21st of May 2016. It's after the advertisement date.
After the last date of submission of an application.
After the last.
But why do you have extended the time?
That is something which your lordships have held against us.
That's a stopper that will come at your, if somebody else comes forward, you can understand. When you are coming forward, despite the fact that you extended the time, are you not stopped?
It's there. What I can submit, my lords, is since that original certificate was way back of 2007. We thought that
would have rejected their candidature.
We thought that maybe there was had the certificate been within the cutoff date of the advertisement, then maybe he would have
reflected it.
Our letter is couched in a manner which is haunting us, my lords. Now
You wanted to produce immediately the renewal updated.
Renewed/updated.
So
Renewal updated.
So renewal means what?
Well, there are two things. If this letter amounts to extension, that is something which goes against me. The other thing, my lords, is the cost of 5 lakhs. So there are two issues. Now, so far as this certificate is concerned, which my young members have found out. So now whether he has, suppose your lordship now gives us a direction to take him. This has to be worked out because even this certificate has now lost its value. The 3-year period goes.
The process was initiated at that point of time, and he was declared as the suitable candidate for employment. Way back during the validity of the certificate.
So there, my lords, there are all these disability certificates.
Had he been in employment during that time, suppose if you have not taken that particular plea, then you do not require the renewal certificate while in service.
I was just
You
pointing that
don't require. You do not require.
this certificate at page 19 is just a certificate of participation. Thereafter, whether he has actually got the certificate or not, we are not privy to it.
Have you taken that?
No, we have it. We have it. That's something which we lawyers have found out and we are trying to. There your lordship was correct. MS Gill, in view of MS Gill, we cannot take this. We just wanted to draw your lordship's attention that this is something which is there. So now we are a central government undertaking. So when we have to take someone, it has to be with all proper things. So if your lordship can take care of this, and maybe give directions that you give all updated certificates and then we will be able to take. It's not a concession, but just.
So because the first letter certificate is concerned,
It's a certificate of participation. But when the certificate, you submitted the certificate of 2007, which is not a certificate of participation.
that was a certificate, that was a first letter certificate, that was.
Yes.
That was the certificate, that's the award of the
It
certificate
says it's the award, is the awarding of the certificate.
that I have passed that examination.
Correct. So that is required. And this is the certificate of participation that you participated.
What I obtained instruction from my client manager, he stated that after participating in the examination, all the certificates has to be forwarded to the New Delhi office. From there, the award certificate has to come. So it takes a lot of time. If
And we knew it that the certificate has a validity of 3 years.
but my number if at the present time he will be obtaining that award certificate, then his candidature may kindly consider.
What?
If at that relevant point of time, after the participation of
If the validity is given at 3 years, then an expired certificate does not really permit a right to view. Even if 15 days extension was granted to you,
yes,
yet you will have to give a renewed certificate because it was the expired one. And you have not submitted the renewed certificate.
that instruction I have to take whether he had submitted thereafter within
This
the
is
time.
what he says was the
Within the time
certificate of
stipulated.
participation,
Within the
not
time
a certificate.
within the time stipulated, whether he had submitted the awarded certificate or not.
But he says not. He says that you have not. You have, that you must have that certificate with you. Like the one.
If then some time may be granted, I will produce it by way of.
So
an
what
affidavit.
for yesterday, last time we heard the matter? You knew it that this is what the plea has been taken by you. You could obtain a certificate of participation in the year 2016. The certificates must have been reviewed.
But I have the original certificate.
So it is there, 2016. And what was the last date?
Last date, as per the extended letter, 15 days. Otherwise, advertisement was 23/2/16. And 20th March 2016 was the last date of the advertisement.
When you extended?
Extension was given on 13th of May for a period of 15 days. That will be on 28th of May.
He was examined on 4th May.
4th May, he took the examination and certificate might have been issued.
Must have been immediately there. Why did you produce the certificate? You had that certificate with you.
That information I have got.
What?
Whether at the time of submitting the letter on 21st of May, whether he had produced the certificate,
It was
award of certificate or not. As per the letter from my learned seniors appeal brief, his assessment that only the certificate of participation has been submitted. I have to take specific instruction to that one.
But the plea of participation was not taken by you.
No.
You
That's
proceeded, that certificate was produced.
that we as lawyers found this out. That I'll be very fair to the court. We as lawyers have only found it out. It was not even the authorities also didn't know that this certificate. Also say, my lord, that we have not taken this in the counter before the single judge. Only here we discuss. So your lordship's view that Mohinder Singh Gill with stare at us is correct. So far as this plea is concerned.
So that is the whole problem. I just invited your attention.
I bow down to that. Regarding costs, if your lordship wants to persuade your lordship, I have one judgment which says that if a party misleads or if there is any misrepresentation, then the exemplary costs are to be awarded. Just to persuade your lordship regarding that 5 lakh cost. This was just, we showed him some grace and that extension we gave. Thereafter, he came up with this and matter is before your lordship. Paragraph 8 of 2010-12 SCC, page 70. Just to persuade your lordship knows this. Exemplary costs are levied when a claim is found to be false or vexatious or where a party is found to be guilty of misrepresentation, fraud or suppression of evidence. In the absence of any such finding, it will be improper to punish a litigant with an exemplary costs. In this, my lord, in this case, we just wanted to give him another opportunity. We wrote that letter, and thereafter, of course, we didn't give him the benefit. But that's about it. That may not deserve cause, my lord. These are the 2 points.
Paragraph 6, the last of, argument point.
My lord. That remains one of those points. But that letter from our side, actually, we also wanted to accommodate him. But then the manner in which the certificate came after the cutoff date of the advertisement, we being PSUs, we have a lot of internal queries. So that's the reason why we ultimately rejected it. And that letter, of course, is something which may amount to extension of time.
So it's more the recruitment to the post of
Attendant.
Attendant.
Group 4.
Group 4 attendant.
in the
Paradip Port Authority.
attendant in the hospital run by the Paradip Port Authority or what?
Paradip Port Authority. The specific office address has not been given under which office I have to search. It has only been mentioned as attendant. Serial number 12. Page 60.
To present the field. Directed against the directed model in 17 was 2044. By the single form. Those are WP, the C number 4144 of 2016. By the requester responder. Seeking. Lead to the form of a device. Upon the fabric. To issue the letter of appointment to the post of our attendant, which was reserved for a candidate belonging to a liberal family. It is beyond giving of doubt that pursuant to the advertisement noted by the to fill up the post of the requester responded to this individual. Within the times, the conditions enshrined in the said advertisement includes the submission of a first state certificate as well as the caste certificate as the said post. It was kept for a reserve category, which according to the minister, it was duly complied with. The petitioner was adjudged as the suitable candidate, but it was subsequently detected that the first state certificate submitted by the petitioner being one of the preconditions, one of the requisite conditions. You can say that advertisement has lapsed by passage of time, and a letter was issued on 13th May 2016 by the Secretary Paradip Port by Secretary of the Secretary of the to submit the reviewed slash updated first aid certificate within 15 days from the event date. Indubitably, the renewed slash updated first aid certificate was produced. But later on, the appellant proceeded to reject the candidature of the Westminster respondent on the score that the certificate subsequently applied by the Westminster respondent was issued beyond the last date of submission of an application, and therefore the candidature of the percentages liable to be cancelled. The single bench next up, the single bench proceeded on the footing that the moment the time to while the certificate is expended by the recruiting authority. It cannot take a rebound and repeat the application. There. The second bench further found that there has been an unjust enrichment of the legal rights accrued in favor of the principal responsibility at the behest of the appellant, and therefore the writ petition deserves to be allowed with exemplary costs of rupees 5 lakhs. The next one, the Board of Contention in the instant appeal on behalf of the appellant is restricted to a point that there was no official to extend the period for submission of the certificates issued subsequent to the last date of submission of an application. And therefore, even if the authorities have permitted the registered respondents to submit the renewed as updated first aid certificate, it does not confer any right into him or be considered to such posts. It is further submitted that the single bench has wrongly construed the letter dated 13th May 2016 as an extension of the period for submission of the application or the certificate being one of being the requisite conditions in terms of the said advertisement. And therefore the improved judgment is liable to be interfered with. The certificate which was appended along with the certificate which was appended along with the original application issued by the competent authority with regard to the first stage was valid for a period of 3 years from the date of the examination. The said certificate reveals that the examination was conducted on 31st October 2007, and therefore the validity of the said certificate is 3 years from the date from the same date, which admittedly expired in the midnight of 30th of October 2010.
21st October.
From the date of the examination is 31st. In the midnight of the 30th, sir. Not anniversary to anniversary.
The award of certificate was issued on 21st.
It was said from the date of the examination, sir. Examination was conducted when 31st October 2007. He is unable to find. This is the examination.
এইটি 21st হচ্ছে তার পূর্বটা দেখুন পূর্বটা দেখুন both are yours service.
Give evidence.
I'm given to you, both the
Examination date is
31st.
the confusion is because in one it is 31st, on the next page it is 20.
Award date is
So
21st.
in any case, the next page your lordship may see, there is
I
20.
do not know which one is correct.
In any case,
I
both
got
are
the
his
first one.
certificates. Both are the writ petitioner certificate.
So,
In any case, it had lapsed before the
whatever.
cutoff.
The midnight of the 30th October 2007. 2010. So that's it. What I'm saying. Which I Though the advertisement does not specifically indicate that the certificate to be submitted must be valid as on the date of the submission of the as on the date of the last date of the submission of the application by the intending candidate. But normally the certificate having a lifespan must remain alive as on the date of offering the candidate to by the intending candidate. Precisely for such reason, the appellant caused a letter dated 13th May 2016 inviting the attention of the minister in this regard and permitting him to deposit the renewed / updated first aid certificate within fortnight from the said date. None of the intending candidate has approached the court challenging such letters issued by the appellant. But subsequently, the appellant itself proceeded to reject the candidature solely on the ground that the certificate the certificate submitted within the extended period cannot be termed as a due compliance. Due compliance of the conditions enshrined in said advertisement. A authority cannot approbate and reprobate at the same time. The moment the authorities detected that a certificate submitted along with an application has a limited duration and expired by influx of time, the decision not to have been taken relating to the candidature of the respondent. Once the moment the authorities decided to extend the time for submission of the said certificate, and a due compliance is secured by the intending candidates, it is too late in the day to take a rebound and reject the candidature of a candidate who ultimately was successful in the recruitment process. We do not find any express matter having put in the advertisements in extending the period for submission of the certificates. And therefore, the moment the recruiting agencies have extended the time to submit the said certificate, it cannot take a contrary view, and therefore is stopped by their own conduct and representation. The doctrine of estoppel has received recognition in the legal parlance, and the authorities cannot be permitted to act contrary to the stand already taken and duly communicated either by their conduct or representation. The single bench has construed the letter dated 2016 as an extension of time for valid participation in the recruitment process, which cannot be said to be inferred and or opposed to in the legal jargon, opposed to the legal jargon. We appreciate the attention raised by the applicant that the imposition of the exemplary costs in a routine manner should be eschewed, and a sufficient safeguard should be taken in this regard. So we have been reminded of the observations of the made by the Supreme Court in Satyapal versus Union of India and another reported in 2010, Volume 12, SSC page 17, that the imposition of the exemplary costs could only be made in the event the claim is founded upon a falsity or an outcome of a fraud misrepresentation or suppression of the fact. But when a debatable point is raised, inviting the adjudication by the court, which does not appear to be vexatious or of such magnanimity amounting to a wastage of the judicial hours, the court should not venture to impose an exemplary cost. The enlightening observation of the above report is reproduced as under paragraph 8.9. Oh, paragraph 8 and 9. In view of the legal pronouncement in the above noted decision, we have no hesitation that the court, the single bench, ought not to have imposed an exemplary cost. While allowing a writ petition filed by the writ concerns from. We hasten to add that at times when the claimant is defeated by a delay, the court may impose costs as a compensatory measure, but after recording the proper reasons relating to the conduct and the action of the authorities, which resulted into a deprivation without any reasonable cause or the grounds. We do not find any such element in the incident matter, and therefore we are unable to persuade ourselves to countenance the imposition of exemplary costs against the applicant. The order review is modified to the extent that the portion by which the cost is imposed upon the applicant, the same is hereby aside. Stop. The remaining portion of the order included in the instant appeal is hereby affirmed.
And so
He has given like
3 months time as
no after
just
Item number 24.
Please,
one.
for the appellant in one of the matters. Yes.
Appellant learned ASG is actually.
I am for the appellant.
Yes,
I
sir.
am for the appellant here. Yes, I am sorry, extremely sorry. My apologies in the matter. Can I seek a small indulgence in the matter if I am not causing inconvenience to the court? I am
What?
little away and little handicapped. Can I request to have it day after tomorrow, Wednesday or Thursday, so that physically I can be there in Odisha and I can just want to address the arguments in this matter. I am little away, bit handicapped.
How far you are away?
I am in southern state.
What to
So,
do? Yes,
Wednesday,
what do you say?
yes.
He wanted that he should come and physically argue the matter if it is fixed day after tomorrow. Yes?
Yes.
Day after tomorrow? Day after tomorrow will do?
Tomorrow, 2 p.m. or what's the kind of fixed time so that
What to say?
that is a difficult. Australia possession getting the employment.
What do you say?
For me, no problem.
This is the fresh admission.
Yes, a fresh admission. That's what. Fresh matter. Anytime.
So in the first hour,
No problem. For me, no problem. The day I want, that's all. Whether it's in the first half or
day after tomorrow.
Mr. K.M. Nataraj, the additional Solicitor General of India, appears for appear along with Mr. Haripad. K.M. Nataraj, the ASG, and Mr. Shaktidhar Das, senior advocate, along with Mr. Haripad Mahanti. Appeared for Mahanadi Coalfields Limited. Requested for an adjournment for 2 days accommodation. 2 days accommodation. Requested for 2 days accommodation. List this matter on
22.
day after tomorrow.
please.
Just ensure one thing, because I find that so far as the appellate is concerned, he will be single-handedly arguing the matter in all the matters. So far as the respondents or opposite parties are concerned, I think there are numerous opposite parties. So you choose 2 or 3 counsels, they will address.
Very well.
So choose amongst yourself?
Yes.
Not everybody.
Yes.
So all of you can sit together and then find out the modality.
That's nothing more to be added. No other document, no. The documents are required to be filed on the basis of writ proceeding records.
And the IC and the proceeding
Writ proceeding.
Many of us from the central government councils, and we are Coal India. We are representing the Coal India.
So one will be enough for Coal India. No, pro forma you have nothing to say. It's only good for your appearance. Yes.
Item 25.
Yes.
Coal India Limited ये दिल्ली में नाम रखे थे अजकर appearance तो कर for Coal India Limited CGC. कारण ना लिखी गई कल सीजीसी पर
Yes.
Last time directed to take instruction for payment of compensation. Payment of compensation for everything. Demolishing my houses.
Yeah, my lord, although the repetition has been allowed, but this appeal only on the question of compensation, because although that was a prayer in the repetition, but that was not considered, no direction was passed.
Correct.
last occasion directed me an instruction. But I have received instruction because state is also proposing to file an appeal, challenging because they are basically aggrieved by the judgment passed by the Honorable Single Judge.
And this judgment was delivered way back in the month of March 2025.
Here the collector has sought for the permission approval
So
of
it's-
the revenue department.
When? Immediately after or?
They have 90 days.
Is on 16/5 they are
You have 90 days. No? Appeal,
appealing.
30 days.
30 days.
On
30 days or 90 days?
30 days.
30 days. That is
On
is
16/5.
uniform to all.
Because state was not a party. So the collector has to seek the approval of the state authorities to refer the appeal.
State was
The
party.
department was not made party.
Revenue, divisional commissioner, secretary, all are party.
No, order of the collector was set aside.
Yes.
Then what remained?
Order passed by the revisional authority was set aside. Because the revision was preferred by the Tahsildar, challenging the order of the appellate authority. Because the
So subdivisional officer is the revisional authority.
not the subdivisional authority, it's the collector with the
But he says that the order of the subdivisional officer is found to be illegally sound
yes,
and is hereby upheld,
yes,
passed by the collector is set aside.
yes. And the question before the read court was whether the Tahsildar, who being a statutory authority under the statute to initiate the eviction proceeding, and essentially his order was the subject matter in appeal, and the appellate authority allowed the grievance of the petitioner, and whether the Tahsildar for a revision. Because that finding state now the collector they have decided to prefer an appeal challenging this.
This is up to you. We can't. We are today, there is no appeal.
Today there is no appeal.
That's all.
Only your lordship had directed to obtain instruction regarding the compensation.
That's all. So your appeal is neither here nor there. We can't go into that. It is up to you who have to take a decision.
Your lordship may go to paragraph 16, man. 16 of the single judge. They have
Yes.
taken my land and there no land is left for settlement. It is
What it says?
noted that the disputed land has already been utilized for public infrastructure, including a railway overbridge and the Raurkela Municipal Corporation Market Complex, leaving no land available for settlement. This court finds it contradicted that Tahsildar having issued the demolition order himself and having found continuous possession until demolition. He had mentioned that
What was the nature of the land, sir? This land belonged to whom?
that government, we are
The land belongs to government.
yes.
You were the occupant.
So when for more than 30 years and thereafter 60 years,
More than?
60 years, man.
Huh.
Because in 1993, it was proved that it is a settleable proceeding. In 93, thereafter in 2019, it was also proved that yes, it is a referable proceeding and it is a settleable proceeding. Thereafter, refer the matter to Tahsildar for deciding the matter. Tahsildar passed out of that. The petitioner was the residing.
So what is your claim that being an occupation for 60 years, so you have acquired a right of ownership?
Yes, as per Article 300, it is a lot of.
Article 300, capital A applies.
Yeah.
Article 300, capital A applies.
Yes, man.
Applies. Was-
We have
Right to property
right to property.
at the behest of a wrongful occupant. Tell us that it applies.
It is a human right, man. Human right means individual.
How?
As per decision, there are 60.
Right to property is a human right.
Yes, man. The decisions are cited in the Validity of Sort.
Human right.
Yes, man. Even though not a fundamental right, but a human right. constitutional right and human right. It has been proved by the.
Constitutional right I can understand because right to property was included in part 3 at the initial stage, later on
Yes.
taken out and now find place in Article 300 capital A. So it is a constitutional right, but
There are the human.
subject to the established procedure of law.
Yes, ma'am.
So mere in occupation for 60 years becomes a
Yes, ma'am.
absolute right of ownership.
Yes, madam. This is the decision I am reading.
What? So you are claiming an adverse position against the state.
The petition contends that even if petition is occupying land without authorization, the right to shelter is a fundamental right under Article 19(1)(e) and Article 21 of the Constitution of India. The petition further contends that the right to property is a constitutional right and the basic human right that cannot be taken away without legal sanction.
So that legal sanction has already been done. Encroachment proceedings are initiated against you.
That is illegal.
How can it be?
Without notice, without our.
Did you challenge that encroachment proceeding? This encroachment case against you?
Encroachment case was there, but we have proved that we are more than 38% as per OPD Act, Odisha Prevention of Land Encroachment Act. If
What it says that if his person is more than 30 years
yes, then
in position, so
right will be settled.
a right would accrue in them
Yes,
as a owner
yes.
or as a settlee.
This is the law, madam. This is the law. Yes, you are, Ganesh Engineer are also quoted in his
Civil court or.
No, I do not know how. Well, the person that we will become a right. Section 8. Yes.
If it is.
What is so?
Mere obligation does not mean that the position has become worse to the
Position. The position will not.
8 years, madam. It's an 8 years. Where in the course of proceeding, stated under section 4, 6 and 7 and 8 against any person unauthorized occupying any land, it is proved by such person that he has been in actual, continuous and undisputed occupation of the land for more than 30 years by the date of institution of the proceeding. The proceeding refers the case to the supplement officer. Thereafter, on the receipt of the order, the reference under subsection 1, the subsection officer shall give the Department of State Government other than the Revenue Department. Either it is the law that Revenue Department, when land is belong to Revenue Department, there may not be a Tahsildar. So Tahsildar has no jurisdiction. It will file the return there. As per settled law of this amount.
What do you have to say about this?
In fact, his 8A application was considered by the Tahsildar, was rejected, and against that he preferred appeal. The appellate authority set aside the order passed by the Tahsildar.
Correct.
It was the subject matter of challenge in the revision.
Correct.
Now the issue which was raised before this, before the Honorable Single Judge, whether the Tahsildar being a statutory authority is empowered to prefer the revision. The court gave a finding that the Tahsildar, that there being no specific provision under the statute, he cannot prefer the revision. Now, if your lordship will look at just one contention that was raised before the Honorable Single Judge, that is at page 25, clause VI, that is the submissions essentially advanced before the Honorable Single Judge and which has been recorded. Just place one paragraph, my lord. Says the petitioners claim that the house, shops, well, the garden and trees were demolished without proper notice is inaccurate. The report from the revenue inspector Raghunath Palli, dated so and so, clearly states that the petitioner was not residing on the disputed land at the time. Instead, other individuals were occupying the land during the construction of the railway overpass. This was the specific submission. However, that has not been analyzed in the judgment operative portion, but the Honorable Court, if your lordship will kindly glance to para 70, despite the Tahsildar's attempt to dispute the petitioner's possession, the factual findings from the spot inquiry tell a different story. The findings of the spot inquiry categorically establish the petitioner's continuous possession of the land, thereby making the case referable under 8A. Now, if this is the finding, then 8A application is yet to be adjudicated.
My Lord, Tahsildar mentioned in his order that the petitioner, the enclosure was in possession.
Who will adjudicate or who will take 8A
8A
application?
the Tahsildar. The Tahsildar, but if the land has to be settled, it has to be done by the collector.
No, collector. Sub-collector.
So in that event, the sub-collector has to take care of that.
Sub-collector. Settled the land. He mentioned that it is
The
a
instruction I have received, your lordship, my lordship.
So is referable. So 8A has to be considered.
Yes. Because 8A,
Then why you are
unless
challenging?
8A is finally adjudicated or
In
considered.
an adjudicatory authority
Yes.
can challenge the further order. Is a quasi judicial authority. Can he challenge the order to sustain his order? Then
That was the issue.
tell me. A civil judge, junior division decides a matter, and thereafter the matter went to the first appellate court. First appellate court reversed his judgment. Then the civil judge, junior division will challenge the judgment of the appellate court before the High Court in second appeal.
My lord,
Is a correct way of doing it.
before the civil judge junior division, essentially two parties, they are
Again, he is an adjudicatory. He is an adjudicatory authority. He adjudicates. He is a quasi judicial authority. Can he?
But here only the application is considered. Your lordship may kindly appreciate.
Considers.
Here only the application. There is
So can
no
he go?
adversary. It is
He
only
would
the
write.
state.
He would write to the government or the respective department whose land is wrongfully occupied by him. The department will take care of that. Tahsildar. Oh, he who adjudicated will go and file an appeal.
He has filed revision, not appeal.
Or whatever.
Yes.
Sir, revision and appeal is the twin sisters.
Both are there.
One has more powers and others has a limited powers. But both can set aside. Can they not set aside? They can set aside.
There is one decision of the High Court division bench that Tahsildar has no jurisdiction to find a division. It has been quoted and usually given by the petitioner.
Sir, I am also surprised with this, that this act has come. I am also surprised with that. A government land enclosed, then the settlement.
Section 8A speaks.
Sir, the act speaks, sir, not 8A, the act itself speaks. I'm really surprised with that.
This is Odisha prevention of land and.
Whatever. It's the act itself is a prevention. Then why the act will confer a right?
Only one section is permitted for settlement. The other sections are eviction. Other sections are for eviction.
What to do? Where is the provision for compensation?
In that book, there is but the decisions I have quoted and cited on Article 300, they must pay compensation for illegally dispossessed person. Because it is a human right and custodial right, that right.
Sir, the right of settlement is already vested on you. If they have taken some actions, divorce the law, that's the only way is the cost, nothing more than that. And non-imposition of the cost, whether appeal lies.
They have taken all the land we are in possession and they utilize it for the overreach and
Maybe the compensation can be determined by them, that you do not know what is the value of the land, how, on the basis of the rental value or on the basis of what. Your right under 8A is the settlement.
Yeah.
Means the land would be settled in your favor, rent would be assessed by them, rent would be collected by them from the day when you are there in the position.
Yeah.
So what compensation to you?
Don't settle. Then you are entitled for our land has been taken away and utilized by the government.
Not your land, sir.
It is a decision matter. So 10 decisions I have taken. I taken. And I did among that course at Photo 6.
Which one?
Decisions has been cited by the.
Which one you have cited, sir?
And page. Different decisions I have cited. Is entitled for compensation.
Here only I
Right to
can,
settle.
my lord, no rights until now, my lord, today your lordship is
No.
hearing the appeal, no rights until now has been created. So far as the petitioner is concerned.
I understand.
Yet to be.
So I wanted to have a judgment.
Reproduction. Yes,
Which is
quoted in the CORAM.
Petition. That's it.
Quoted 4 to 5 decisions.
Which item?
If you ask, if I'm Vikas
35.
and another.
Two.
Cooperative Housing Society. LTD.
Is it complete? Last. Removes.
Whether
Removes.
a decision of decision I will, if your lawsuit once I.
What judgment? You are relying on a. What are the decisions? One after another, show us.
Means
You have-
payment of compensation.
Mr.
Sorry.
You have furnished it before the writ court.
Whether
You have furnished it before the learned single judge. That is along with your written notes you have given.
yes.
So that you please cite one after the other. DB Basnet. You have cited DB Basnet.
Yes, I have cited 10 that decisions. But
You read out the citation.
I submit all the decisions by Xerox copy tomorrow.
We have the copies of writ which you have given it to the writ court.
Yes.
That please,
I have given-
that is there. We have the copies.
Yes. Written statement.
Only one decision we have got, that is DB Basnet.
Yes, any other judgment you cited? Apart from this
Yes.
DB Basnet. Other judgment? Only one judgment you have cited. Of the Supreme Court.
Yes, all are Supreme Court.
Oh, only one you have cited, sir. Any other judgment you have cited?
Right to property is said to be a fundamental right by the Constitution.
That is in DB Basnet, it is held. It is quoted.
I have quoted, I will submit also, I have quoted, but just now, all the judgments cannot be sorted out. I will submit tomorrow all the judgments which are confined for payment of companies. I have filed the read court and I.
So all those judgments are pointed to the issue where a person who has a right in the property, means right duly crystallized.
Yes.
If he is deprived of the property without due process of law,
Yes.
then he is entitled to a compensation, and Article 300 capital A will definitely come into play. Here is a case that admittedly you do not have any right in the property. By mere long possession in the property of the government, a right to get the settlement of the land in your favor accrued in you. So long the land is not settled, can you say that your right under Article 300 capital A is infringed? I am asking you a very simple question.
Written argument I have given to the read court.
Yes, it is. In the written arguments, he has.
What the judgment?
Judge.
I filed the written argument and.
Where is the
Just-
written
just-
argument? Again, I have to open.
Yeah.
Read.
These are the judgments I had filed in written argument.
The written arguments.
Written notes of argument.
Argument.
Okay.
Just come down to page 5.
I
5.
5.
Okay. No, you are correct. But again, I am saying that is where you are saying that it becomes it has an element of a human right. Is a valuable human right and as well as the constitutional right. No difficulty. Again, please consider two things.
It has been considered by Supreme Court judgment. What can I do? It is not in the law. But
I am not saying, suppose if you are an admitted owner of the property,
yes,
the property belongs to you.
yes,
The state has illegally taken away your property without initiating any acquisition proceeding, without determining the market price, without the payment of the compensation. You can definitely claim under Article 300 capital A.
Yes.
Here is a case that admittedly you do not own the property. Correct?
Yes.
But you are in possession of the property for a pretty long time.
Yes.
Your possession has been taken away by them without the, let us see, procedure of law. Correct? Though they initiated a proceeding. This act, Section 8A, says that the long continuous possession of a specified period creates an entitlement of settlement of the land in your favor.
Yes.
But that too by initiating a proceeding, inviting the department to give a show cause why it should not be settled. So long the settlement is not made, can you assert a right to property under Article 300 capital A? I am asking.
One thing, what happened, I am saying, one, the sub-collector, object authority refer the matter to Procedural. Procedural inquire the matter. Inquire, he was told that since land is not there and occupied by the government authority, it cannot be settled. This was the order of.
So there must be an order of settlement. The moment the property is settled, then the right is created in you.
Yes.
So long that is not, no right to property is created in you.
This is the, he told that the land is not there or available. So it cannot be settled.
Proceeding has not
Then what can be
culminated
done?
into a right order of settlement.
What was your counter there?
In paragraph 17, that since there is no land available, how it will be settled? This is the question. And they have taken all that without any authority of law. This is the Your Lordship, what can be done?
Sir, you can protect your position.
Yeah.
Your position was disturbed. So for that reason, you can raise a grievance that if you are in settled position, you cannot be dispossessed without due process of law.
Yeah.
But right to property in that sense,
Right to property owner, the decision says that without payment of compensation, no.
sir, provided it is your property, till now it has not,
No.
unless the order of settlement is made.
And there are property, government property, adverse person. So that decision is there.
Show us, adverse possession is not an automatic one, sir. Adverse possession under the Limitation Act, that's the only right which is created. One has to prove that the possession is continuous,
Yes.
hostile,
Yes.
uninterrupted,
Yes.
and there is a legal maxim, nec vi, nec clam, nec precario. These elements have been proved by a person. Otherwise, how can you claim a adverse possession?
It is automatically proved by the since we are
How?
in possession, they are admitting. The government is admitting that.
Then I can give you pipe judgment which says that mere long possession in the property does not mean it's an adverse possession.
The adverse person will not come into picture because this law is separate.
That is what I say, sir. It simply talks about the continuous possession.
Yes, continue.
So why you are taking me to adverse possession?
No.
Then you are put into more
No.
trouble.
There are decisions. Even if the petitioner is an adverse person, that should be paid compensation. This is the decision.
Provided the court recognizes the adverse possession, because adverse possession creates a title.
Yes.
Here your title has not been created unless the settlement order is passed.
Yes.
You do not acquire a title, you acquire a possession.
Yes.
So,
But no, the Tahsildar should have settled after remand of the matter. But
so why compensation at this stage, sir? First thing is the settlement has to be done, and then you are deprived of the property that has to be done. Then the compensation theory will come.
then we have no right to compensate. We should restore.
First thing is 8A proceeding, as the court has single bench has directed, that makes you entitled to claim a settlement under section 8A that has been decided.
Yes.
Decided. Tahsildar rejected 8A proceeding, is it?
Yes.
The appellate court allowed it. Then against that, the Tahsildar went into a revisional court. So your right accrues on that day of the settlement.
Yes.
Make a claim of compensation there.
If land is not there, then how it will be settled? This is the question, madam. It is a critical case. The land has been taken away. If there was land, then it is.
But the land is not a movable property. So there cannot be a diminution of a land. The land would remain a land so long this earth exists. True. If they have taken up, land is also there. So that will be given back to you.
Alternative land, that should be.
They will give that land to you.
The alternative land, that land.
Same land.
Madam,
Same land.
some land has been utilized. Well, from.
What? How?
By radio quality construction and market complex, other.
They will remove it.
They can-
Demolish the entire construction.
They have, they should remove it and restore us the land. We have no compulsion. We don't want compulsion. Otherwise, it is a suggestion that they should give us some land to in another place, government land.
Anyhow. Just to post authority for the purpose of.
Building. And it is absolutely referable proceeding, yes, mentioned. That's absolutely. I'm reading my name. In view of the above discussions made in the following paras, I am of the opinion that the instant case is absolutely referable proceeding. Therefore, the Tahsildar Raulkela is directed to take necessary action as per the provision of law contained in the relevant section of OPL Act rules, giving due opportunity to the pronounced in the open court. Then the extent this is the it is the absolutely referable proceeding. In another judgment, also this sub-collector in 1993 has passed this type of order that this is absolutely referable proceeding, and the Tahsildar is directed to refer the matter to my court. This was the order, my. I am reading that order. That also I have. In view of the above, I am of the opinion that this proceeding is absolutely referable proceeding for which the appellant made submissions. In the circumstances, the petition is allowed with the instruction to the Tahsildar to take necessary action as per the provision of law contained in the relevant sections of opinion. Pronounced in the open court. It is 1963 and this is 1993 order. Thereafter, 2019 order, further sub-collector order. Because we have proved our more than 30 years possession by different authorities were inquired. We have kept the land swap. In that, we have kept the land swap from encroachment, other encroachment. We have kept the land swap. Therefore, the bridge and market competition. Have there been another encroachment that was difficult for the government? I think so. Since last 33 years we are fighting, minority petition is fighting. Back and become old. Going to different courts, appellate court, high court, and material. For proving its position.
Annex 17. That is single bench in earlier round of litigation. Clearly stated about 8A, then compensation. But yes,
But that is still pending.
revision.
So that's still pending.
So he said, so court has done.
I say there is a referable and then he has to take a decision. He has to take a call, final call. And then he will decide.
In view of the matter where divisional case number 7 is still pending, the court is of the view that the same needs are. Once court has stated this, can you raise the plea that this has been accepted by him? So should he now take a plea that yes, the revision is not maintainable? So only thing is this has to be adhered to.
No.
The earlier
And then it has to be. Yes. That's all?
Yes.
Thank you. Right, Patil. You just send the fact.
Document result is judgment.
What's the judgment? Don't worry, it will appear for orders in the court. Don't worry.
Yeah.
Just follow the list.
Just point out one thing here, subject. So far the order passed by the appellate authority only says that it is a referable proceeding. It doesn't decide anything on so far as the title of the petitioner is concerned.
I have what do you find? This is what has been. Yes, call the next.
you have accepted the earlier writ. Earlier writ you have accepted, both of you.
It will appear in the next week. As for orders.
So 17 of the petition.
As for orders, this book from the library.
It is there. It is there.
Okay. With the file. Yes, call the next.
This is.
Pray one thing will.
My lord, I appear for the petitioner in this.
Meantime, state takes this for appeal. We can.
We don't know.
My lord, I appear for the petitioners in this matter. I am challenging the order of this honorable single bench dated 27th March 2025, placed at page 35 of this writ appeal. The facts of the case, my lord. The petitioners are villagers and scheduled tribe community members, forest dependent scheduled tribe community members of Jamnagar village, which is in the Mayurbhanj district. And by virtue of the scheduled tribe and other traditional forest dwellers recognition of Forest Rights Act 2006, their rights, forest rights, my lord, specifically their right to observe their customs and rituals, have been recognized, and a title deed to that effect has also been issued by the respondent authorities all the way back in 2014. I have annexed the same, my lord, as in page 70 and 72. The translated copies are at page 156 and 157. My grievance is this. Till 2022, my lord, I was in that location. I was observing my customary right, and I was performing my pujas in the sacred grove. 2023, and in two batches, my lord, in 2015 and in 2022, there has been eviction, relocation of these villages, including the petitioners here in my lord. And such eviction has been arbitrary. This is our contention. Apart from that, my lord, until 2022, we were performing our pujas. 23, we were denied. Again, when we showed letters and our CFR title deeds, presented it through the letters to the forest authority in 2024, we were allowed. They actually made arrangements so we could perform our pujas. Suddenly, 2025, again, suspecting that there will be some problem when we try to enter the our own village area, we provided a letter and we were rejected. The rejection letter, my lord, is at page 99. 22nd January 2025. That's my cause of action.
When is the rituals? When you want to perform your ritual, what was the date?
We actually informed the same to the authority, my lord, by letter dated 22nd.
What is the date?
My lord, we wanted to perform during that time, my lord. Like we wanted to enter. It was time of.
Which one? What is the time? Because you wanted on a particular auspicious day or auspicious time.
My lord, we had tried to state that collapsing rituals at Jamnagar on 23rd January. We wanted to perform.
So now it's over.
Yes, my lord.
So
subsequently, my lord, no. The point that I'm trying to get to at, my lord, is that these community members, tribal community members, have uses their sacred grove and the sacred spaces for rituals time to time, depending on the lunar cycle, etc.
Correct.
We have been periodically denied our rights, though that is a legally recognized right. Number one. Number two ground, my lord, is that we had already raised all these issues. That is the crux of my case, my lord, before the Ministry of Tribal Affairs, which is the apex nodal authority as per section 11 of the Forest Rights Act. And my lord, Ministry of Tribal Affairs intervened in this matter, has actually passed a specific direction upon the authorities to review not only the eviction process, but also to restore my right to access these sacred spaces. That direction, my lord, may kindly take up.
then tell me then what happened.
Yes, ma'am. Now, Ministry of Tribal Affairs letter 6th March 2025 is the point at page 141, my lord, I've included. Despite this order, now whether this order is binding on the authority or not, I submit, my lord, as per section 12 of the Forest Rights Act, authorities includes the district magistrate because he is the chairperson of district collector, who is the chairperson of the district level committee. And for the forest department, deputy field director, field directors are also members of the very same district level committee. So they are authorities under section 6 of the Act. And by virtue of section 12, specific or general direction of the nodal ministry are supposed to be considered and observed by them, which they have. They have continued to deny my right. Subsequently to this case also, my lord, I have approached the forest authorities asking them that allow.
Now, the reason is very interesting, my lord. That is provided at the rejection letter at page 99. The rejection ground is that there is an ongoing tiger supplementation program. So there is an enclosure that has been built and a tiger has been brought in, which was not there till 2024. It has been brought in. And then they argue that there is a question of right to life. Obviously, because there is a tiger, we cannot let you enter. Very well. Question is, this right to life, how was it supposed to be understood or supposed to be considered? My lord, there is a protocol which they are supposed to follow. That is their own protocol under the Wildlife Protection Act of 1972. The protocol is at page 100, my lord. And that protocol demands that when such tiger supplementation program are to be undertaken, you have to conduct a prior social impact assessment. You have to take the community which is residing in such forest. You have to see whether they understand the purport of it. And if you think that there is a danger, then you're supposed to reconsider alternative sites, not put the tiger in the same space. And this protocol, my lord, has been violated because no such impact assessment, no such prior information, no such intimation to the villagers. Some of the villages, I am one of the petitioners, my lord. Some of the villages are still residing. This is not a public interest matter, my lord. This is a writ appeal against a specific order. But it is in our knowledge there are still villages which are inside. No such test have been and the tiger was put in. So not only was my forest rights recognized under Section 3 of the Forest Rights Act violated, not only the order of the Ministry of Tribal Affairs, respondent number 1, not observed, their own protocol now. This protocol is the basis on which how you conduct yourself when supplementing a tiger, that is reintroducing a wild animal such as an apex predator such as tiger. Now, one cannot approve and reprobate. You cannot accept parts of the protocol, which is something that allows you to do so and not follow the particular provision. That is at page 103 particularly. This is my case in a nutshell. These are the legal grounds on which I am seeking, my lord, that the single bench's order failed to look into these legal grounds.
There is no discussion what he has argued. We do not find there is any discussion in the judgment.
There is nothing discussed.
Nothing is recorded. Simply says that this is supplementation programs are continuing, and there is a danger to the human life. So nothing can be done. That's the only.
Basically, only this honorable single judge explained this paragraph 5 Narasimha.
I have read it. That's why I am saying.
Yes.
That's the only thing it has said. What he is saying that there was already a tribal welfare department's mandate upon the forest, and then everything is to be done. There is an SOP which is also there that in order to conduct this program, this is a supplementation program relating to tiger. The consents, the social audit reports have to be taken about in relation to their the occupants of the tribal areas which are there. Nothing has been done, and then you implant it.
Maybe let's keep it to after 2 weeks. In the meanwhile,
Implant it.
State also
What is this? State has not done. It's a forest department, central or a state?
State government, my lord.
State government
execution of the program is completely upon the state
government. That's what you have done.
No copies have been served, my lord, but
Look at it. We heard so patiently, and then
no copy have been served.
It's been served while filing your option.
It's up to Union of India. Only you want to state out.
you have not served the state.
It's served virtually, your lordship. Because without being served, defects won't be removed, your lordship. Without being served.
It cannot be served virtually.
Without being
has to
served,
be
defects
given
won't
to
be
a
removed.
state council or in our copy receiving council. Otherwise, there is no.
Now you serve the copy.
I will serve my
Serve copy, I'll take instruction.
After 2 weeks. Interesting. It's interesting.
There is a delay or no?
No, my lord. In filing the writ appeal, there has not been any delay.
Delay, 4 days delay? There is no
No,
delay.
it is not. It is not. No, it is not. Item number?
26.
There is no reflection of a delay. There is no reflection of a delay.
27th March, my lord, is the order. 24th of which we have.
Stamp report. But how is it not reflected in the docket note?
Your Lordship.
How listed section are listed? Check it out. The report is delayed.
Pardon to. Case has been filed on 25th. By mistakenly, they have mentioned it as defect. But order is of 27th. I have filed it on 25th, Your Lordship. Your Lordship. And it has gone to the record section on 2nd. That's why it was mentioned.
Let us see on the next day. Yes. Passing order for them. And copy to be served in course of this day.
Deeply.
Respondents to leave. Six. That's either resolve your appeal. That's why you are implement. Grips are there. Which of the respondents are there?
SCST is there, department is there. So both the department there.
Which of the respondents?
OP4, sir, OP3
SCST party, SCST. Collector Moirvanji is a party.
There are 2, 3, 4, 5, 6,
All the
7.
All the opposite party except one.
Except one, all are state authority.
8 also. Integrated Tribal Development Agency.
I think it may be from central government.
Project Administrator.
2 to 7, man.
2 to 7.
2 to 7.
Mr. Das. Mr. Parial. Someone. You are for 1.
Only one.
8 not necessary.
8 if necessary, but I don't know in the state or something. I don't follow this other
You are
is the
not sure.
state or something.
You are not sure.
I'm not sure. Project administrator, tribunal level.
Notice may be issued to 8.
Notice to 8. Requisites. Notice in IR also.
Item 27.
Trivial issue. Very strong. Lordship will see the order passed by the Honorable Assembly. That is at page 21. man. Before page 21. And your Lordship see under what jurisdiction this order has been passed. Admittedly, between the bank and the petitioner, civil suit is pending. Either party are claiming against each other. Bank wants to back it. Petitioner appellant says that I am to get aliens house rates, differential house rate. Civil suit is pending. Status quo was passed. Status quo is on record. The other side doesn't challenge the status quo. Doesn't challenge the status quo. Though he has a remedy of filing appeal. Straightway approaches 226. Seeking a direction to the police. Let the police be directed to assist the bank to vacate the premises. And the day when the matter was listed, first day, we are appearing and asking us some time, we will reply. It's a 226+2. The Honorable Singh disposed of the matter. Even your Lordship will see from the order, the entire suit is prevented. The Entire suit is previous.
What is the suit for?
That suit for realization of area rent and for eviction also.
So he wanted to give you a position.
Right? No,
You have put a lock and do not allow the bank to enter into.
By now, by the order passed by the Honorable Single Judge, bank has vacated. By the order, after this
They have
order,
already
they
shifted.
have shifted it. So that part of the issue is over. Now I am only on the limited prayer that rest of the issues which are, because the Honorable Single Judge has closed the entire thing, kindly see, madam. The suit should be at to decide, the rest of the points should be decided before the in the pending civil suit. The entire suit is in order 226 decided. Kindly see para 9. And we have not been given opportunity.
No, he has not decided the suit.
Kindly see, Lord, looking at the factual scenario, it is further directed that if there is any dispute with regard to deposit of rent, the said rent shall be deposited. It's not only dispute, it is not only rent. But I only ask my lords, I only request my lords.
Nothing has been done.
Beg pardon.
Nothing has been decided.
Lord,
They say there is a dispute as to the rent. If it is deposited, the court will, at the time of final hearing of the suit, will decide it.
It's the only thing, Lord, your lordship may just clarify one line saying that whatever issues are left open, they decided there. That's all. That's all. Otherwise, the civil court, once the bank deposit the current rent, my suit will be dropped.
What?
You see, the rate, I am asking differential rate also. That is not covered in the order. So those aspects have to be decided.
The bank has gone, so there is no question of any future rent.
No, future, not future,
So-
differential area rate.
Said current trend. You
That's
said current trend.
no, the suit, our prayer for differential area rate is also there. So that's also should be decided. That's all. I mean, I am not asking for any direction to pay. And 226 bypassing alternative, everything without giving us opportunity, this order straightway has been passed on the day one when it was listed. Only explaining to the extent that civil court will decide the rest of the issues. That's all.
Where is the bank?
Bank, I think.
On behalf of Mr. Vishwal, I'm appearing for Punjab National. Yeah.
In the read jurisdiction, status quo order's effect is taken away. In a read 226 jurisdiction, order of status quo is taken away in para 8. Kindly see. But basic fundamental of civil law. Status quo is appealable. How can you sit in appeal under 226 against the status quo order? Kindly see para 8, man. Kindly see. Basic fundamentals. Rather, I should not use the little harsh. Kindly see. And status quo order is on record. Bank is not challenging filing appeal. Straightway approaching 226 and status quo order is overridden. With regard, we apprehended before the court, we filed an injunction application that without making payment of our area rent, let the bank be injuncted from leaving our premises. And status quo order was passed. Rightly or wrongly, it was passed.
Yes, what do you say?
Oh my God.
Now it is implemented, they have already.
I cannot have any, I cannot develop it thereafter. But only thing, keep it, your lordship, in appellate jurisdiction, direct to keep it open. Rest of the issues to be decided by the civil. That's all.
Injunction application is pending or it has been finally disposed of?
It's pending. Page 71. Page 64. Your injunction is pending or disposed? I cannot, it's order to go, status quo of the kind. That is here, not. Actually, the status quo here. Yeah, yes, hello.
First thing is generally class. The demands is against your landlord. Reliance. What is the public element in work? Maybe a public undertaking.
I have not gone through the brief because it is.
The cause of action is the determinant factor.
No, my lord. Actually, that is not the fact before this court. That has been filed because we have approached the police. There is a public agitation, and we approached the police to open the bank because he has locked the bank. That is my fact before this.
You have also left.
Yes, we have deposited the entire amount, and because the premises is not in a position to hold the bank also, because it is a dilapidated stage.
So your duration of occupation comes to an end in 2021.
Yes, madam.
There was neither an extension nor a.
No, in spite of several requests, they have
continued in occupation.
well, in spite of several requests, they have not extended the period because there is a dispute between the brothers. It cannot be done. The documents are with bank.
But the bottom line of the entire episode is that you continued in occupation.
Yes, ma'am.
From 82.
We have given the rents to that extent also.
Now you are no longer there. You are operating from a different premises.
Yes, ma'am.
Now you wanted the suit for recovery of the determination. That is to be done. They have claimed in terms of the lease.
Yes, I have.
Must have claimed. Now the wrongful occupation is also one of the factors.
Yes.
Yes, that will be decided in the suit. We have already deposited the amount there also.
That's the case of a mean profit.
Yes.
We have already deposited the amount there also.
That will be decided.
They said in the suit, that's all.
And already we have deposited the amount as per this honorable court's direction. We have already deposited the amount before the court will also. Whatever they have not taken, because there is a dispute between three brothers, who will take the rent?
But there was when the injunction application was taken on now.
Yes, ma'am.
If I correctly understood what he says, I have not seen him.
Yes.
What he says is correct.
Yes.
That they wanted to restrain you.
Yes.
From leaving the premises without deposit of the entire rent. And the court has passed an order of status quo on that application. Yes, the court passed such a direction like paragraph E.
And your lordship, my prayer in
It's not a appellate court.
My lord, I have not prayed in the writ petition also to that extent. My prayer is to open the bank, or else we may be allowed to
Not open the bank.
Yes.
Not open the bank.
Both.
Not open the bank. Kindly see prayer in the writ petition.
Yes.
Kindly see the prayer in the writ petition before the honorable single judge. You have made a prayer. It is therefore prayed that this honorable court will graciously please to admit this writ application so and so opposite party. Why the opposite party is not taking step by providing police assistance for shifting of the branch to another premises, not opening of the branch. This is the prayer in your before the honorable single. Right, right. I don't take an exception.
All their furnitures.
I don't take an exception.
Yes,
Doctors, everything is inside.
I don't take an exception. No, it's never locked, my lord. It is never locked.
Yes, my lord, that is locked. That is the police report. Police report will say, my lord.
We have not locked, my lord. It's not, my lord. I don't take an exception to that. We have never locked it. We want that.
They have not taken any other steps. Otherwise, your right have been in our late.
Correct. But they have not, in fact. Why?
They have not. It appears that they have not.
No, they have not locked it. That's a wrong
Yes,
statement.
ma'am. That has been logged. The police report is there also.
So that should have been decided in the suit.
And if he will log the premises, then how the bank will run? There is a public agitation for that reason.
Where the opposite party number?
Before the honorable civil judge. Opposite party number 5.
Five were cited by the respondent number one. Respondent number one here.
Respondent number one, yes, respondent number one.
Respondent number one.
Yes.
As by the institution, the city being ordered to take the conceding. Of the WTC number 11452. Primarily on the ground that it was that the High Court ought not to have usurped the power of the civil court. Civil appellate court. Nullifying the effect of an interim order of injunction. The application for injunction is pending.
No, it's disposed of. Final order has been passed. Yes.
Interim order, the order of temporary injunction. By which the parties were directed to maintain status quo with regard to the property.
Maintain status quo over the suit land as on today till disposal.
With regard to this property being the subject matter of the civil suit number 590 of 2022.
Right.
Pending before
In the court of civil judge, senior division Bhadra.
Court of Civil Justice, Senior Division, Bhadra. Undeniably, the appellant and the first respondent entered into an agreement for use and occupation of the portion of the property for banking purposes and for a duration as reserved therein. They said agreements last lease expired in the year 2021 by flux of time. And admittedly, the same is not renewed as of now. The appellant approached the civil court for recovery of the area amount and also the amount on the basis of the terms and conditions embodied in the said agreement. Which is still pending. Since the bank was operating at the premises after the expiry of the period provided for the suit for recovery, the prayer for recovery was also you have made the prayer for recovery.
Recovery damages.
However, the first respondent took a defense that the appellate wrongfully and illegally put a padlock on the main entrance door, which impedes the functioning of the bank at the demise premises. And later on, across the
State Bank of India
to remove the obstacles put thereon. Now, alleging inaction on the part of the police authorities, the petition was filed. And when the impugned order, the court not only directed the bank to shift upon after vacating the demise premises to another place. subject however to the deposit of the rate with the civil form, where the suit is pending. According to the appellate, such order impinges upon the order of the temporary injunction passed by the court in presence of the parties, which can only be interfered with by the appellate court under order 43 rule 1 within brackets small r of the procedure and not otherwise. It is submitted that without exhausting the remedy of an appeal provided under the appropriate clause, the writ court should not have transgressed its jurisdictional circumference and pass an order which would negate the effect of the temporary injunction passed by the civil court while disposing of an application under order 39 rule 1 and 3 of the procedure. Obviously, the moment the approach is made to the civil court to insist of the matter, the writ court should be slow and circumspect in interfering with any adjudications, be it tentative or otherwise, under Article 226 of the Constitution. The writ court should not overreach the domain of the civil court if the dispute is of a civil nature and must confine its adjudication within the contours of the reliefs laid therein, which in the instant case is inaction on the part of the police authorities in rendering assistance to the first respondent. The exercise of power of judicial review by the High Court should not be done in every mere manner, but with a great caution, as the right which is purely civil in nature cannot be decided without evidence to be made in this regard. More particularly when the civil court is citizen of the suit. Be that as it may, despite having noticed that the order of temporary injunction is diluted to some extent in the interim order, we are informed that the bank in the meantime have shifted to another place after vacating the device premises. So, according to the counsel for the first respondent, they have deposited the rate as they will rent in terms of the agreement, and therefore it cannot be said that they are in default. Since One of the reliefs claimed in the complaint appears to have been extended to be that is eviction against the first respond. But the other issues pertaining to the default, the area rent and the rate of rent on the basis of an agreement remains pending. We feel that any observations made in the order should not have any persuasive impact on the civil court if deciding the issue framed on the basis of the respective readings of the parties. It is open to the civil court to issue the frame on the frame of the respective readings and permit the parties to give this level and the decision on such issues shall be taken independent of any observations made in the order. These such observations that he is the result of no order.
Here, before Orchid State Bank is the apparent bills.
I asked what he suffered.
What the bank suffered bills. Normally, courts do not. Normally, courts do not
copy notes, sir.
Copy notes, sir. Yes.
Copy.
I filed a caveat also,
When
but
a caveat is there, then you have to serve.
still they have not served copy.
Yes, yes, sir. Not sir. It is.
Yes.
Yes, sir. Here, what has happened? Normally, courts do not interfere in commercial decision of the bank's bills, in day-to-day commercial operations bills, banking operations. Here, what has happened? Bills. The Honorable Single Judge bills has framed three issues. Bills. The first issue bills, the reduction of cash credit limit bills. Court interfere bills, and in the judgment I have wondered, all along bills, no reasoning, nothing, not deliberated, not discussed. Even though there is a caption in the judgment discussion and analysis, nothing is discussed. And court said that a reduction of cash limit is illegal. Just briefly, bills, I am apprising you also this. First bills. Second, with regard to bills, petitioners bills, allegation before the court.
Cash credit limit.
Cash credit limit bills. Yes, what has happened? There was because of the sick financial health and because of cash sort of inadequate cash flow bills, and for various other reasons as per the guidelines bills, the cash credit benefit which was granted to the borrower bills was not supposed to be bills allowed to be continuing, for which bills after discussion with the borrower by the branch head bills, it was discussed that we are going to reduce this cash credit limit, and that and the phased manner, not in one go bills, 14 to 9, then 6 bills in phased manner, and that was discussed. Communication was made by the bank to the borrower. Borrower bills accepted the communication in writing, saying that yes, I accept this communication, and bills thereafter when bank went on reducing the limit bills as per the earlier communication from 14 to 6. Then he came up before the High Court, before the Honorable Single Bench, saying that it is not legal and proper bills. One, apart from the other, one objection I raised bills, that when the very basic decision was not objected to, primary decision has not been, you have accepted that. You can't challenge the consequences. I have resorted to Amarjit Singh's judgment, you are supposed to doing that. Without challenging the primary decision, you can't challenge the consequential action. In any case, bills, I have bills referred to bills from the very bank statement which your lordship will find many a times, several times, the closing balance stands above the sanction limit because that is always supposed to be below the sanctioned cash rate limit or below the drawing power. Because either of it, if it gets
That you were at fault, but you permitted him to avail his cash limit, not this.
because I have classified the account as NPA, non-performing.
That they do not serve.
Correct.
And then you have, as per the RBI.
Correct. Well, I had, that is also one of the issue before the court below. Sorry? No. The surface is, this is a cascade mirrors. But here what has happened, there's a,
the balance or the transaction or on the basis of high obligation.
no, collateral security is there.
There.
Collateral.
Cash base or.
Because we permitted the borrower to at least go on working. Whereas if the cash flow is reduced.
Why is the account becomes
No, whereas what happened when the for 90 days, for a period of 90 days, whereas as per the that there is a circular of the yes. As per the yes. On income recognition, asset classification, provisioning, notification of the RBI mirrors, if it falls on a period of 90 days, the bank is to classify the account as NPA mirrors. That was done. And after sorry,
merely 90 days does not mean NPA. There are other criteria.
Other criteria as well, mirrors. And after criteria are found to have been attracted, account are declared NPA. Then he made the deposit. And the moment the deposit was made, it was declared NPA on 30/12/24. On the very next day, bank withdrew NPA classification. REIT was filed in February 2025, alleging that this NPA classification is bad. Because there is no cause of action survives. But despite of the clear fact emerging from the pleadings of the writ petition, your lordship will find there is no cause of action available to the petition challenge NPA mirrors. Honorable Court will have given finding. I'm sorry to say this. And third, there is a third issue is penal interest. Penal interest, as per the pleadings mirrors, I have verified also. The allegation is for a period of April to December. April to December mirrors, according to the petitioner, he has alleged that the penal interest is capitalized because capitalization of penal interest are not permissible as per the Supreme Court judgment also. We are in that quarrel with that. Because RBI has also given a circular not to go for in 2023 minutes that capitalize there cannot be the penal interest can be debited, but it cannot be capitalized. Capitalization mirrors leads to again levy of interest on interest mirrors. So that is it. Now we have made a very clear stand in our counter affidavit saying that we have not capitalized for the period we are claiming to have capitalized. And despite of such a clear denial mirrors, Honorable Court below said that you reverse this. My humble submission is that here are three of the issues mirrors. Tomorrow mirrors.
Interesting point that.
Yes. Not even a single fact was there, what my senior friend has stated. From a single document they have produced, the RBI says there are threefold tests given by the RBI under the circumstances where an account can be, particularly CCOD. So, not even a single condition fulfilled. They say
after the deposit, they immediately record that.
Correct.
Implications. Really show that particular account is there. Maybe for a brief period, it doesn't ultimately, it does not really impact your commercial activities or your commercial solvency or, say, the stability or credibility is a more appropriate term. Because I know the civil sometimes creates a problem. So they have to take care of that. If they have lifted, that will not go.
That was lifted. I specifically commissioned.
Secondly, they wanted because of the period when you did not search.
These were the cruxes. It is CCOD.
Limit. In a basic, obviously, it is always used in a phase-wise manner. One cannot. Sometimes they utilize, sometimes they deposit, then it goes on like this. Up to a particular outer limit, which is already provided. So in that case, so long you have utilized the money, so much to it's a matter of convenience. They have said that there were certain lapses on liability.
No, but what I submit one thing, just for 2 minutes.
Now, they have filed a
In a
content
case
petition.
credit, in a
Content
case
petition
credit,
is posted tomorrow.
Let me kindly appreciate one thing, that's a pass order.
My friend has filed a
In a
content
case
petition
credit,
and the matter is listed tomorrow.
It is not, if I can submit.
No, just I'm bringing to my lord's notice.
Okay. Lord, it is not a term loan where a borrower has to, yes. So in a case credit limit, the borrower is entitled to use up to the limit. And the bank is responsible or the entitled.
That the borrower will not serve.
No, it is up. Otherwise, it well, otherwise, if the borrower failed to serve, so a single document, single statement of account where the limit was overdrawn. So what's aware of these things?
Overdrawn statement is there.
Overdrawn. Is it like the mistake that you committed?
Yes.
Later on, when you approached, they agreed, and then there was a conscious decision to reduce that particular limit.
Yes.
But the moment you utilize it, you have to deposit the rent. The interest.
The interest are being debited by the bank within the limit. Where is the question of me paying interest? It's a case credit. Yes, that is what the process is. I'm sorry, but
I do not know the commercial charges, how it works. There are two ways of giving a cascade limit. One is after looking at your accounts, what is the popular account balance? It appears to the bank that there is a solvency in the business that is running. Sometimes the bank can say that I permit you to utilize the credit limit of, let's say, 2 crores. A separate account is opened for the purpose of utilization. Whenever your account exceeds, there is no crore, but you wanted to correct something. You can withdraw that particular custody from that. You may withdraw 5 times rupees, you may withdraw 4 times rupees, but not beyond 6 crores, the sanction money. Second is, cascade can also be given upon or hypothetically your goods.
It's a property mortgage. It's a property mortgage. I'll take just 2 minutes.
Then utilize, but this does not absolve you from
paying interest. The payment was there.
And the balance is
may I submit one thing? The payment was.
Let them do it. You wanted your response into it.
May I submit one thing? May I submit one thing?
When you want.
Any date, tomorrow?
When you wanted to hear, so you have filed your response in the proceeding page?
Yes, they filed response. I was petition.
They are the petitioner. We have filed counter before the honorable senior. No.
Written submissions filed.
No rejoinder file.
Not supported by an affidavit. Written submissions are not supported by affidavit.
Because it was nothing there in the counter affidavit. It was nothing there in the counter affidavit. May I submit one thing? Lordship can pass order. That's 2 minutes submission, if Lordship permit. What they did, the limit was for 14 crore. On 8th November 2024, the limit was for 14 crore. 13th November, they reduced to 6 crore without giving any reason.
What they say actually that it was a conscious decision.
Best.
Discuss with managing director.
And then you agreed to.
No, and till date, there was no overdrawn. So what that is where the RBI says that three set the principle they have set under the circumstances where the bank can declare an accountant out of order. If that is not satisfied, they can't declare out of order and take coercive action against me. It says, kindly see the RBI circular.
I find there is interesting issues that are there. Yes.
And despite the interim order also, they kept on charging penal interest and capitalizing it.
No, that is not there. That is.
I filed previous.
Something by the civil council for the appellant that the trial court has proceeded to decide the matter before the beliefs as well as the principles of law applicable in this regard. And therefore, what is immediate interference? It is further submitted that the findings resolved in the improved order is not corroborated by the stand taken by the appellate in the counter affidavit. More particularly that the penal interest was never capitalized by the bank.
NPA also. No project.
Non-performing asset
Already withdrawn.
was subsequently was reversed.
Withdrawn.
Slash withdrawn. The court ought not to have to pass the ultimate. After hearing, sorry, what's your group? The counsel for the respondent number one.
Respondent number one.
Sole respondent. Sole opposition. Yes.
The respondent appears and submits that despite the caveat having lost the copy of the application as well as the memorandum of appeal has not been served upon. So because the element record of the applicant has served the copy of the memorandum as well as the application. In court today. We find that the points raised by the applicant is considered. And our process is a ground for we are informed that the contempt application is taken on by the respondent with this
Mostly tomorrow.
Just for that, we can be a team and decided to be about take down there. I will follow a promise. We request the senior judge not to proceed with the contempt.
Contempt petition number 2513.
This is the next take of the dispute. This is the matter on the immediately after this. Again or first, whatever.
Speak immediately by not third, fourth. 3, 4th I will be in court.
38 or first. Can it be done? 38 or first?
First. Let me do first.
First July?
Well,
Yes.
My lord, just troubling my lord.
What certificate?
In item 59, I'm again troubling my lord. This there is an interim order against the appointment of the GST member, and for which one of the members.
The real statement of India.
No. Item 99 I'm mentioning about this 49. In that case, my lord is vacation is passed in order.
I have a personal.
May I pray, my lord? Lord, Attorney General given a consent to appear in this case. Can be day after tomorrow, my lord. I'm going day after tomorrow because the attorney is given time to appear. That's why I'm.
Lords, item number 49, Lords, the petitioner counsel appearing, Lord, Mr. Das has some difficulty. Let the matter be taken up 26th. We just filed the rejoinder to him. Serve the copy of.
So tomorrow, let
28 and 29 same, my lords. 28.